enthusiasm. He always had this feeling of being like a little boy with a new toy. That excitement that was to me so captive, so reminds me of him, is one way that I will always remember him. I will also say Joel's fascination with privacy could be a major pain, because he was constantly objecting to the email system and the servers and this and that, and he was right. He was right, and much more sensitive to all of these issues before any of the rest of us. And lastly, I'll just say that the most inspiring thing to me about Joel was not simply his vision and his groundbreaking work, but the spirit with which he approached and took on his final challenge, which was his illness. And I remember the suddenness with which his diagnosis came, and his tremendous determination to carry on his work, to carry on with his family and his loved ones that were so important to him, and to continue to support and be a cheerleader for others, even during some of his sickest and most difficult periods. He never failed to be supportive, energetic, enthusiastic, and optimistic. And so I learned a lot from Joel Reidenberg over the years, and not just about information law, but also about what it means to be a good person, what it means to support others, and what it means to look to the possibilities in life. I'm also grateful for the work of Tom Norton in directing the center, both worked with Joel and has continued it forward. The faculty director now is Olivier Sylvain, but Tom has been a rock throughout. Tom was a student of Joel's and a mentor, and Joel was his mentor as well. So I just want to thank you, Tom, for all your work in leading CLIP through this tough period. Finally, on the subject facial recognition, it's a hugely important subject. This was driven home to me this fall, where one of the issues that I've been dealing with as dean is the administration of the New York State bar exam remotely, which was done for the first time, and it was done through the use of these AI proctoring systems, where the students were required to have their cameras on their laptops open at all time, videotaping them. And the software would then identify things that it viewed as suspicious. And right off the bat, you couldn't really get into the system without a facial recognition entry key. And so first they would take your picture at some earlier date, and then the day of the test, you'd have to log in and get recognized. And there were huge concerns with it and problems. I think the bar exam in the end just sort of, they waved everyone in, figuring they could then sort out the problems later. They didn't stop anyone from taking the test, but it really drove home to me both how important the technology is and how dangerous it is in terms of if it's inaccurate and makes mistakes, it really has dramatic impacts on people's lives. The AI proctoring experience, I still find really weird, I have to say. And I think that the jury is still out from my point of view on how it's all worked, but I'm sure there are many more experts on this subject than me who will be sharing their thoughts today. So thank you for including me. Have a great discussion. I wish you all the best for the holidays and for 2021. Take care.
Thank you, Dean Diller, and we are looking forward. Well, yeah, I have to fix the light here, but I'll do it yeah, soon. Yeah, we look forward to continuing the great collaboration among the institutes and among nations. So yeah, and hopefully we'll go on with this activity, but in person next year as well. So the next one to give the opening remarks is Professor Tom Norton, the Executive Director of the CLIP, who worked with Professor Reidenberg for many years since he was a student, and he graduated from Fordham Law, and he continues the legacy teaching about privacy and other issues at Fordham Law. So thank you, Tom, for supporting all this activity and for continuing working with me as the AI and IP and blockchain project. Thank you so much.
Well, thanks, Shlomit. I'll be quick here because I know we have a really robust and exciting program to get to. First, I want to thank Dean Diller for his kind remarks and really for being such a champion of CLIP and for his really strong appreciation of how important information law is in making it a priority at Fordham Law School. So thank you again. We really appreciate it. And I also want to thank you, Shlomit, for putting together such a great program in remembrance of Joel, who, you know, as Dean Diller, you know, described, meant so much to so many people. He was certainly a friend and mentor of mine. So thank you for putting this together. I know how much time and effort it takes to do this, and so it's great they're able to do this. Also, thanks to all the speakers who are devoting their time today to talk about this fascinating topic. I can't wait to hear what you have to say and what your viewpoints are, and to hopefully be able to engage in some discussion with you about it. And then also to all the attendees, thanks for joining us. Thanks for participating. You know, this is, as Shlomit mentioned at the beginning, a busy time of year. So it's great to see so many of you on for this event. And I would just add, you know, CLIP has lots of similar events and programming throughout the year. So if you're interested in attending more events like this, you can learn about them by visiting our website and joining CLIP's email list. And more generally, if you're interested in learning more about CLIP and what we do, you can feel free to contact me directly. I'll put the CLIP email address, my email address and the CLIP website in the chat. And then finally, I also want to thank the Fordham Information Law Society, the student group that's co-sponsoring this event with us. We work with them closely to, you know, to keep engaged with students and to promote events like this one. So with that, I'd like to turn it over to Connor Goetz, its president, for some opening remarks. So thank you again.
Thank you. Yeah, that's a great chance. I mean, people I usually speak with in person. So yeah, at least we have a chance to meet each other via Zoom virtually. Yeah.
Thank you, Tom. And thank you so much, Dean Diller, for your kind remarks and support. My name is Connor Goetz, and I'm the president of the Fordham Information Law Society. We're a student organization that explores the intersection between law and technology and their impact on civil liberties. We're honored to be co-hosting what promises to be a phenomenal workshop with the Center on Law and Information Policy. I really couldn't imagine a better group of speakers and moderator in Professor Yanisky-Ravid, who speaks at Info Law Society events every year. If you'd like to learn more about the Info Law Society, you can feel free to shoot us an email at fils@fordham.edu. I can go ahead and put that in the chat. Thank you very much, and I hope you enjoy the holidays and really look forward to this event.
Yeah, thank you, Connor. I mean, I just want to mention how happy I am to collaborate with you and working with you, and for the opportunity to give some of my new research and the new research in the world about you know, information law and about advanced technology and the challenges of advanced technology. And knowing you, I envision, a great future for you as a gifted lawyer and much beyond. And I'd like also to mention the former president of the FILS, FILS, Daniel Schwelbe, who for making the connection and for staying in touch and going on working in the privacy regime. So yeah, it's great. All these centers at Fordham Law I really enjoy working with. And yeah, we'll start the program. And our first speaker is Professor Patricia Sanchez-Abril from University of the Miami Business School, the former Vice Dean. Professor Patricia Abril is a leading scholar in privacy. Her articles are considered milestones in the field of privacy. During the recent years, until recently, she was the Vice Dean of Miami Business School, Miami University Business School, where she teaches. She graduated, she got a JD from Harvard Law School and BA from Duke University. And I want to mention that I first met Patricia, Professor Brez, in an annual Fordham Law Clip, the international conference that Professor Reidenberg used to organize every year. So it was a few years ago, and during the snowy day, very similarly to the snow that was part of New York this week, we could hardly walk in the streets of New York, and where we tied a long last connection. Patricia, she's a brilliant speaker that always receives wonderful feedback. So I'm thankful for you for joining us and opening this significant workshop and presenting your your thoughts about facial recognition and privacy. So thank you very much. The floor is yours.
Thank you, Shlomit. Can everyone hear us? Yes?
Yeah, I can hear you very well.
Great. Well, greetings from Miami. Don't let the turtleneck fool you. It's 75 degrees and balmy here, but I am delighted to participate in today's event in honor of Joel Reidenberg. In addition to his obviously illustrious academic career, I think the few interactions I had with him were so memorable because of his generous spirit and his energy and the energy with which he propelled and led CLIB. So it's an honor to be here, and also an honor to be here with my friend Shlomit, who we have forged over the years a wonderful friendship, both personal and intellectual, and I'm very grateful for that as well. So because I am a privacy advocate, I decided to start my talk, and I have the honor also of framing the issue for the next couple of hours today. But to start my talk with an anecdote that is, well, private. It is an anecdote about me and my husband and a debate that we've been having for years. So as you now know, I am a privacy researcher, and I teach business law and ethics. My husband is in a very different field. He's a radiologist, he's a scientist, and he's an excellent diagnostician. So every once in a while, when we are in a public place, let's say an airport, my husband will turn to me and point to a stranger and diagnose some malady, say, based on the person's maybe pallor, age, gender, gait, we'll say this person has this ailment. He finds that interesting and compelling and kind of part of his practice. And I find it super creepy. This is the debate that we have. And he says, no one is harmed here. There are no consequences. Science is about observation. This is clinical. I am just seeing what I see and commenting on it. And it's out there. This person isn't hiding it. My rebuttal to that is very intrusive. The person is entitled to keep whatever the person has private, hasn't shared it with you, you're not the doctor. And we would probably be appalled if some stranger was commenting and extrapolating on our private matters based on how we looked or where we were or how we walked or how we sounded. Plus you might be wrong, right? So this is the constant debate. And this little debate between me and my husband, I think is a good starting point, because it's an example, a very small example of the debate that we are having worldwide about privacy, about what is the nature of privacy? What is the nature of privacy in public? Who is entitled to it? What is the role of science? What is the role of technology? What is the role of law? What is the applicability even of law to some extent in running to catch up with what is the current reality? Now, obviously, my husband is not like facial recognition in that, he's a well-intended doctor. He knows he's potentially biased and wrong, and limited disclosure is just to me, and I'm gonna forget. But that's not the era. That's not where we are in terms of facial recognition. So let me start by talking about kind of classifying the many faces of facial recognition. What are we talking about when we're talking about facial recognition? Because we're really talking about a lot of different types of uses by a lot of different types of actors on a lot of different types of populations for many different purposes. And this is one of the reasons that legislation becomes complex and difficult, right? So at the outset, I want to say that facial recognition undoubtedly has many, many benefits. I have 25 minutes to talk to you, so I'm not going to go into the finding lost, children and tagging endangered species, but we should all recognize that those are there, and that's why we're having this conversation, because the compelling benefits are so attractive, especially the convenience, which, as all privacy advocates know, is probably the death knell of a lot of privacy in many different contexts. So here are 4 different uses and types of, let's say, nomenclature of facial recognition. In the top left quadrant, face surveillance. Now, this is the mass identification of individuals that we know is in use in, over 65 countries, pioneered in China, used to really identify people walking in train stations, in busy places. On the right, in the yellow, is face identification. Now, this has been used since time immemorial, since the beginning of policing, to physically match paper and pencil mugshots to suspected criminals. Today, we know that at least 1 in 4 law enforcement agencies in the United States use databases, no longer paper and pencil, to compare those mugshots to pictures. The more troubling part is that it's not just mugshots, in other words, people who have intentionally posed for the picture and know they were posed for the picture, but it could also be civilian photographs, DMV, or in the worst scenario, in the recent Clearview scandal, anything ever uploaded to social media, making the uses potentially endless and nefarious as well. In the bottom left quadrant, we have face tracking, which is tracking someone using either real-time or stored video throughout. And now the difference between the yellow and the blue is here we are also layering on their location, and in addition to their identity, to track them and know where they're going. And then finally, and again, this is a very simplistic kind of taxonomy, we have verification. Now, all of us have pretty much been subject at some point of a border entry or to unlock your smartphone or device to a face verification that simply confirms, now one-to-one, not one-to-many, that a particular human face matches the preset digital image of the person. Now, if this weren't controversial, we wouldn't be here today. And this wouldn't be the puzzle that it is for law and for policymakers. There are grave concerns about the technology. There's fear and mistrust in it, and not so much in the technology, but also in the human intervention of the technology, in the government intervention of the technology. So much so that back over the summer, IBM made the surprising announcement that it would stop selling and researching and developing facial recognition services. Amazon and Microsoft followed suit with their own pledges and said that they were pressing pause and they were pending federal legislation. Now, for those of us that have very closely studied and focused on privacy law, that's a little bit scary, because as we all know, there is no comprehensive federal privacy legislation. And it's been many, many, many years that people have been attempting such things in one iteration or another. And what we have is basically in privacy law, a power of state local, and federal laws that are sometimes very theme specific and sometimes questionably applicable. So today I'm going to frame my comments really in two areas since I'm the first speaker. I'm going to do a rough categorization of what the concerns are to kind of bin our free-floating anxiety. And then I'm going to talk about the obstacles. What obstacles to regulation do we have? What obstacles to application of the Fourth Amendment and constitutional principles do we see and must we overcome? So the first one, as I said, is a mistrust in the technology, which is of course different from a mistrust in the people who create it and the people who apply it, right? So the first unsettling bit is the invisibility of it, and the invisibility of it in context of our daily lives. We can't put a paper bag over our head, even though we can put masks, but facial recognition is getting better at even identifying us with masks. So we have to go to the post office, to the grocery store. We have to live our lives. And the idea of living our lives in a police state when we don't even know who is collecting and where they're collecting and where they're using it for makes the invisibility very oppressive of the thought of the technology. The technology is also so new, so nascent, that its legitimacy is still in question. Critics have pointed to the fact that there is no evidence that it actually reduces crime vis-a-vis ordinary video cameras. And then, of course, the major concerns are around bias and error and the combination of the two. We do know from very well-respected studies in 2018 and as recently as 2019 that the technology is still bad at identifying people of color and women. And so in these somewhat socially disadvantaged populations, having a technology that we rely on so deeply for things like our very freedom and democracy and the way that our law enforcement works, having these have an inherent bias that of course will be fixed. Of course, like all of the technology situations and biases in other technologies, until that is fixed, it is extremely troubling to think that reliance on it would be blind. Of course, that also leads to error. There have been many reported cases of people mistakenly arrested because the technology would misidentified them. And as we all know, we as humans have an automation bias, which means that we believe, or we tend to believe, what the computer tells us over and above maybe even what our own impression is. Add to that we also tend to believe what we see more than what we hear. And here we have really a perfect storm of potential mishaps, especially in the area of policing and law enforcement. So we also have mistrust in human actors. Where will this data be stored? Who will have it? Can I fix it if it's wrong? How do we know that it hasn't been tampered with? How do we know when we're being surveilled? Who will use our data? And probably almost the most confounding of it all is, what will our data imply about us? What predictive analytics can be superimposed in facial recognition that discover things about us that we are either not comfortable revealing, or are things that are inherently private and shouldn't be known by whatever nameless, faceless machine is collecting it. Here's an example in the white box of a study that was done to identify whether faces were gay or straight. I don't think I need to comment on that any further for you to imagine the possible uses of that, the possible error, the room for discrimination, and other issues that can come of when a machine is inferring certain characteristics of ours. And last but certainly not least, is a mistrust in the government. I mean, the very foundation of the Fourth Amendment in the United States is for us to be free from unreasonable searches and seizures. That means that when we have a reasonable expectation of privacy, that must be respected by every actor. When there's ubiquitous dragnet and suspicionless surveillance, that goes completely out the window, as does free speech, because whatever you say can't be later corrected because it's always going to be on the record somewhere. Freedom of assembly and movement, persecution. Just last week, the New York Times reported that Alibaba had a minority detection tool that could flag Uyghur faces on social media platforms. Now, that's just an example, like whether or not that particular example is true. Obviously, it's been contested by the company. Whether or not that's true, we know that could happen, and the type of discrimination and persecution that could come from something like that is something very, very, very serious. So, where are we, and what has been done? We know, as I mentioned, that today there's no comprehensive federal statute that governs the use of facial recognition in any of its forms in the United States, whether by private actors or public actors. We know that no court has yet decided the constitutional rules governing law enforcement uses of facial recognition technology. So when we say that this is really the Wild West, it absolutely is. And it is a Wild West where profit motives and market forces are likely to move much faster than legislative forces as they usually do. The points in green that you see are municipalities and cities that have enacted bans. I will point out Portland, that in September of this year passed the strongest facial recognition ban in the US. There are two of them there, so that's why I didn't see it in green, because it blocked the use in Portland of technology by private businesses as well as by government. San Francisco was the first city to ban use by police, and Boston and Cambridge and Somerville followed closely after. Most of these blue ones are municipalities that are stopping the use by police as well, and many of them are pending legislation. That is why this is so new. So what are these laws saying? What are they proposing? What are people arguing for? There's a spectrum of proposed solutions, starting with a total and complete ban, which critics obviously contend maybe throws the baby out with the bathwater, as they say. Then there are specific bans. It could be against a certain use, like a specific ban on automated decision making, maybe automated decision making in the employment context, or specific bans against use with minor crimes, or specific bans of use with low quality footage, specific bans by police. It could be by location, maybe a ban in a restaurant, in a social area, parks, schools. Maybe there should be zones where, geographically speaking, by the use and context, it should be banned. Others, and this is the most popular, are proposing a warrant requirement. In other words, in the United States, we need a warrant. The police needs a warrant in order to conduct any search or seizure when there would be otherwise a private case. So whether or not this is in public, of course, most facial recognition will happen in public, that for the use of the technology, a warrant is required. Others have said, well, how about an opt-out regime? How about telling people, you consent, here you go. If you want to walk down this street, here's the posted notice that says you are hereby consenting by walking down the street to be filmed. We all know as consumers what that often means. Others have called for more regulation, such as the creation of a federal administrative office, likening this to the Food and Drug Administration, who, very carefully looks at all, pharmaceuticals and technologies that are going to affect people. Because the potential of harm is so great, maybe we should treat this like a pharmaceutical and not just like any other technology. And others yet have said, well, maybe all we need are algorithm audits, because there's good algorithms and bad algorithms. Let's weed out the bad ones that have bias and let people use the good ones. So really, these are just some examples of some ideas that are out there, some that have been formally proposed. But my next slide talks about why law is not there. The House of US law is not ready yet for the onslaught of facial recognition. And the only reason is time. US privacy law is technology reactive. You can trace most of the legislation, most of the milestones in US privacy law to the root, to the origin of a new technology that someone like me got up on a soapbox and said, this is the end of the world, this is the end of privacy, we have to do something. And then the law reacted. Sometimes in a couple months, most of the time a couple of years later, but our legal system does not have the agility that is necessary to react to what is already happening. The second is that the US law doesn't protect privacy in public. It just doesn't. The tort laws don't, and the Fourth Amendment is just starting to grapple with that concept. And just starting isn't good enough for the situation where we find ourselves. The third is that in the US, privacy actions often have to prove harm with economic law. And the fourth is that we rely, in the absence of all of the others, we've had to rely on a system of notice and consent, which I will also discuss in a future slide. So the first one is that US privacy law is reactive, but variable and slow and muddled and confusing even upon itself. So the privacy torts, which are the civil actions for privacy, were only created in the United States in the late 19th century. In 1890 was the first law review to suggest that, hey, new technologies are coming out that will be shouting from the rooftops what you whispered in your house, and maybe we should think about this. This was in direct reaction to the patenting of the camera a couple of years before, the telephone, and on and on. In the late 1920s, there was another push for privacy law, and this time the challenge was wiretapping. The challenge was still wiretapping in the late 1960s. You see this freestanding phone booth created one of the most important Fourth Amendment decisions that we're still trying to apply to new technologies. And that's the US Katz versus the United States in 1967. And the situation there was the question of whether a police wiretap of a public freestanding phone booth where it was visible to the public and it was outside, whether that would require a warrant. The result of this very important case gave us the reasonable expectation of privacy analysis, which requires these two prongs be met. The first is that the person has an actual subjective expectation of privacy. And the next one is that society accepts that expectation of privacy as reasonable. Over the years, these have been interpreted to mean that there is no privacy in public. Why? Well, under Fourth Amendment jurisprudence, that's constitutional jurisprudence between the government and the citizens, we have two doctrines that are affiliated. One is the third party doctrine that says that once you've given your information to a third party, that information can no longer be private. Why? Because you're not hiding it. It must not be private because private things you hide. If you share something with someone else, like your health records or your cell phone location or your location accuracy on your cell phone, then it is no longer private. And the next one is the public exposure doctrine, which is also once you've exposed something to the public, once it is visible in the public, it also is not protected. When we talk about privacy torts, when we talk about civil actions, the same is true. So many privacy tort actions have died an early death in the litigation process, because even though someone's privacy was invaded, either the court found that it was newsworthy, so it might have been interesting to someone somewhere, or if the person was in public, no matter how remote, but if they could be seen with the naked eye, then therefore it was not. There's a reason that I put a picture of Naomi Campbell scrambling away from the paparazzi into a car on this slide. And it's because we should note that the US system of looking at privacy based on this type of control, if you're not controlling the information, if you're not hiding the information, it is free for all, is not shared by most of the rest of the world. In the EU, we have a 2004 very famous case with model Naomi Campbell. She was exiting a Narcotics Anonymous meeting on the street. She's famous, so it was newsworthy. And she's on the street, and the paparazzi take a picture of her, and she comes out on the front page of the Daily Mirror with a slogan saying, "I am a drug addict." Now in the US, that would have not really gotten very far in the litigation process because she was famous and because she was out in the street. In the EU, because the framing of privacy as a concept is so different, it's based on dignity rather than control, a balancing test is performed. How important is the dignity, the right to intimacy that the person has versus the freedom of expression? So that balancing test saved Naomi Campbell and won the day in a very important privacy in public case there. But in the US, we are making strides, slowly, but we are. And it bears to say two cases, one from 8 years ago and one from as recently as 2, where the Supreme Court in different cases related to technology, Jones was related to the police installation of a GPS underneath someone's car with prolonged surveillance. And Carpenter was related to someone's cell phone location information. Every time the cell phone pinged on the tower, it told the police where, and the police was able to track the suspect in that way. I won't get very deep into these cases, other than to say that the two of them read together tell us some important things about how the Supreme Court is starting to think about privacy. The first one is that they're starting to make tech reactive determination in a digital age. In the concurrence for Jones, both Justice Sotomayor and Justice Alito acknowledge that prolonged surveillance, first of all, is very different from short-term surveillance. Surveillance of a GPS that tracks your location everywhere you go for months on end, first, cannot be done by the human eye. And second, has many more implications that you can learn about it from the person's daily movement. So it's not like my husband in the airport, because we forget, and that's transient, and that's done in a second. Prolonged surveillance can happen, and it is can be extremely inescapable and automatic in our daily lives. So the Supreme Court is starting to catch on this notion, but not soon. The third one is that privacy actions must often prove harm or economic loss. Now, Illinois has the most comprehensive state statute on biometric privacy laws. So in Illinois, it requires written consent before collecting anyone's biometric information, obviously including face geometry. The statute also allows Illinois residents to collect $5,000 per violation for offending violations. Based on this statute, a class action of residents of Illinois sued Facebook for Facebook's tagging feature, in which Facebook would tag or allow people to tag people's face geometry without their consent. This was a very important, it's called Facebook v. Patel. And what happened was that it laid bare a circuit split among the top circuits in the United States. In the Second Circuit, which covers New York and is a very important circuit, in order to bring a privacy claim, you have to prove harm or economic loss. Now, as most of us know, that is usually a bar at bringing a privacy claim. In the Ninth Circuit, they view privacy much looser and understand that a dignitary harm can also be just as noxious as an economic loss. So this went to the Supreme Court, and the Supreme Court denied that figuring out that circuit split. The Supreme Court said that it wasn't ready, unfortunately, because that would have taken us one step further at untangling one of these knots in privacy law. But unfortunately, as it stands today, in most of the United States, even if unless you lose a job and can, prove discrimination or tangible loss due to a privacy violation, you cannot win in court. And finally, privacy law, in the absence of all of the others, has relied on a system of notice and consent. So here are two examples of notices that if you see them, then you can make the determination whether or not you will walk in that area or you will subject yourself to facial recognition. These are of very questionable use. As we all know, as consumers, we just click through these consents. It's not true consent. Many of the things that we are accepting and consenting to are things that are inescapable in our daily lives and our daily routine, and not walking down the street or not using a certain website might make our lives, it's not about convenience anymore, it's about participating in the economy and in the daily life of the digital world. So just a couple of parting thoughts as my presentation closes. The first is the technology it can be very good for many reasons. It has many benefits, but right now we need to treat it like it's nuclear, like we treat nuclear technology. It's so powerful, and its application in the wrong hands can be absolutely deleterious to society, to democracy, to personal privacy. It could have a chilling effect and an effect on how we feel, who we talk to, and how we act in public. So my recommendations and my thoughts are that at this moment, the house isn't ready. So we need to press pause and enact some regulation, which will for sure not be enough, but enact some overarching regulation so that at least the technology and the law can catch up a little bit. The law needs to act quickly. We can't wait for the courts. We can't wait for the Supreme Court. And finally, this oversight has to be adaptable as the technology. It has to be agile because the technology, its uses, its purposes, its audiences are going to change constantly. And it must be applicable to a wide range of actors. We're not just talking about the government versus the citizens like we were when we were writing the Constitution, or like the social media platforms versus the consumers like we were talking about 15 years ago. Now we're talking about a wide range of actors, businesses large and small, IBM and Amazon coming out saying that they're pressing pause. It is symbolic more than anything else. And we need to grapple with the potential, threats of the technology. In the meantime, we are on our own. Here are some creative ways that people have combated facial recognition, either through hats that shine a light. There's some research that shows that if a light is shining from above, it is less easy to detect faces. We could wrap ourselves in cellophane. This is a real example. Make face masks that hide our features just a little bit to confuse the camera. Or of course, there's very creative modern art, dazzle makeup out there that protesters all around the world are using to be able to enjoy the rights of association and the rights of assembly that many of their constitutions otherwise grant them. So with that, and 1 minute passed, I thank you all, and I share my personal contact with all of you, and thank you for your attention and your participation. I think you're muted.
Okay, so thank you. So I just want to say thank you. It was fascinating, and I felt like I learned a lot, even more, even though I'm writing about facial recognition and the risks and the advantages. But I think I like the categories you put these things and all this information about the U.S. law and what's beyond that. For all the audience, yeah, I already received great feedbacks, but if you would like to ask questions, so just write it in the chat, and we have Stephen, the representative of the Fordham IP Law Journal. We have several more, yeah, Catherine and Ziva, and they will be collecting the questions and we'll ask them in the Q&A. So please stay with us. I just want to raise a few more categories that I was thinking about. One is like, is it the technology itself, or the way, or the uses of the way it uses, or maybe the regulation should be on the use and not on the technology, but it might be blurred, these borders. And also, maybe we shouldn't put all the technology in one basket. Like there is like facial recognition, but there is facial matching, but there is also like, you know, Google glasses that also brings like other features. The person is nice, is depressed, and things like that. And there is facial recognition, the target recognizing for, I don't know, future criminal activities and so on and so forth. So maybe we shouldn't put all the, yeah, the technology in one basket, but it was really fascinating. And thank you very much for sharing your thought. And I know you were working like in between all these era to prepare this so wonderfully. So we really appreciate that. And yeah, and I just want to show like a very positive use of facial recognition, which I recently read about. It was in the New York Times and CNN about like bears and birds. And it's really, yeah, I thought it's kind of like reflect the whole dispute from a different angle. All right, so thank you very much. And we are turning to our next speaker. Focus more on the European, which is very, like the law in Europe is very developed from the privacy perspective. So Dr. Nicholas Bugenberger is the Yale Law School Information Society Project, the ISP Executive Director, and is a lecturer at Yale and a fellow at Berkman Center at Harvard Law School. His research focuses on privacy and information law, but he recently focused on competition law, which is also a very interesting aspect, because I know like the use of facial recognition can be for the benefit of competition law among firms, but also among nations like China versus the US. Professor Nick Bugenberger, he held an appointment in the past as assistant professor in the University of Munster School of Law, where he was teaching, and he also was a policy advisor at the European Parliament in Brussels. And he will speak about EU data, and thank you, Nick, so much. Yeah, it's the director we all love, yeah, everyone loves. So yeah, thank you for joining us and sharing some thoughts from Europe perspective and European perspective, which is really, really important in this field of privacy. So the floor is yours.
Shlomit, thank you so much for the invitation, and thank you so much for the kind introduction. I really appreciate this opportunity. A heads up, if you have questions, please feel free to type them in the chat. I will try to monitor the chat on the side and might be able to pick something up. That said, don't be offended if I don't see it. Please raise your hand or make yourself visible or somehow. I'll try to get to that. I will focus on two aspects of regulation in the European framework that mainly shape the deployment of facial recognition software. And that is the GDPR, obviously, although it's first the GDPR. And the second is, I want to emphasize that it is not only the GDPR that provides the framework for facial recognition and its deployment in the EU, but it is also the European concept of personality rights. And with respect to personality rights, unfortunately, I can't give an EU-wide picture because there's no EU-wide framework for personality rights. Personality rights are governed by the national law mainly. And so since I'm from Germany originally, I will try to share a German perspective on that. That does vary throughout the EU, but unfortunately I can't present 27 frameworks. I want to go through that by highlighting 4 steps. And this is just a rough outline of the various steps at which data protection the data protection regulation, as well as personality rights, could come into play. So first is, where do you get the pictures from? Where do you get the video material from? How do you gather the photos on which you train your algorithms? Second, that would be using the pictures to train your algorithms. Third, or the third step would be, what kind of limitations are there for the abstract use of knowledge and algorithms? That's going to be very short. And then fourth, what regulates or what defines how you can deploy those algorithms and this technology specifically to identify individuals. And along those four prongs, I'll try to lay out, or I'll try to point at some of the regulatory framework that governs all that. Obviously, I won't be able to give a full overview here of everything. Time for that is too short. Let's start with the pictures. Where do they come from? Where do the videos come from? And to what extent is it limited? That very much depends so the regulatory framework very much depends on your source. If those are pictures that are provided to you on a voluntary basis by individuals, if individuals have given their consent, then you're, as somebody who wants to work with facial recognition, you're somewhat in the safest place. There are limitations to that, obviously, and sometimes you need a qualified version of consent, but that is the clearest path to get something to train algorithms on. If you're thinking about taking pictures or videotaping public places, for example, then you're already outside of the data protection of the general data protection framework, and you also have to look into the personality rights frameworks that are defined on a national level. And there you will see that there are incredible differences between the present, and I'll include the UK, former member states. The UK is probably one of the most permissive jurisdictions. Germany, Austria, countries with similar legal traditions, some in Eastern Europe have much more restrictive framework when it comes to taking pictures of the public. There are certain exceptions if you do that for artistic purposes, if you want to create art. There are exceptions for research, but generally speaking, you are not allowed to permanently surveil public places to generate a video stream that would then allow you to train your algorithms or to feed your database in order to enable you to engage in facial recognition. The GDPR And how that comes into play when it comes to just filming and just taking pictures, that's actually not that obvious, because for the GDPR to come into play, you always need personal information. And if it is just a picture without any further identification, then that can be tough. It's not impossible. If you can make connections, you can reasonably expect that there are connections to be made between the pictures and names or identities of people, then it comes into play. Otherwise, we're mainly in the area of personality rights. Now, let's go to the next step, to the second step. You have your pictures, you have your videos, you want to train your algorithms. Now you're squarely within the framework of the GDPR. As long as those pictures that you're using or those videos that you're using are personal data. They are personal data if you can reasonably expect that there's any connection to be made between that picture or between that video and an individual. So if you train your algorithm in a way in which you go through matching steps, in which you assign identities in order for the algorithm to then recognize patterns, then you have made that connection necessarily, and you're within the applicability of the GDPR. The GDPR only applies if you process personal data, but processing is incredibly broad. Processing is basically everything that you can do with data, or you can reverse it and you can say, well, if you're not processing the data, then you're not doing anything with data anyway. Now, if you have personal data, if you process that personal data, there's a general prohibition on doing exactly that, on processing personal data, meaning you have to look for an exception within the GDPR. And Article 6 of the GDPR gives 6 general forms of exception, one being consent, and the most prominent being consent. The other ones being, and I'm just going to name 2 others, the other one being you act upon a contract that you have agreed upon. It is necessary for the fulfillment of the contract that you process the data. And another one is sort of a weighing of interest. You have a certain interest in a certain legally protected interest in processing that data, and you don't infringe a protected interest of the data subject to an extent that is not acceptable anymore. Then you're generally allowed to process that data if you fulfill one of those justifications. Now, the GDPR has an additional threshold for as a justification for processing personal data when it concerns biometric data. That is because the GDPR rests on the concept that biometric data is especially sensitive category of data, such as, for example, health data. Now, on top of the general consent or the general weighing of interest, you also need an additional reason, and those reasons are laid out in Article 9 of the GDPR. And that basically just heightens the threshold. So whereas usually you just need consent, now you need explicit consent, where you usually just need to be processing the data based on some legal obligation. Now you need to demonstrate that it is necessary for carrying out obligations that are related. And then there's a finite list, for example, employment and social security protection laws. So you see, there is just the threshold is heightened for biometric data. Now, not every single picture is biometric data, but it becomes biometric data as soon as you use specific technical means of processing. And those specific technical means of processing are exactly the means of processing that are necessary if you want to engage in facial recognition. Because what you then do is you don't just save that picture, but you analyze it. You analyze the details of it, you try to match it, and that process, that's what's specifically protected. Now, once you're in that framework, once you have found a justification to be able to process personal data, then you need to adhere to the principles, to the further principles that are laid out in the GDPR that concerns of fair processing of the data. You may not abuse your now asymmetric relationship. You have to adhere to transparency, meaning you have to inform the subject that her data is processed. You have to update the subject that the data is processed. And in the end, you have to delete the information and end the processing once the justification for the processing ceases to exist. Now let's go to the third step. Third prong is you have trained your algorithm on a data set, on pictures, on videos, and now you have an algorithm. The abstract use of that algorithm, that is not protected by the GDPR. That's clear. Why is that clear? Because for the GDPR to kick in, you need to process personal information, meaning just having the algorithm or using it to do something that is not processing personal information doesn't trigger any of the GDPR's limitations. That means that sort of third prong in what I wanted to lay out here, that can be rather easily answered with, there is no problem with respect to the GDPR. And so far, that is not limited by the GDPR. That is where national governments might be stepping in the future, or even subnational governing entities, and prevent the usage of certain technology or the usage of those algorithms more generally speaking. Let's go to the fourth and final point. That is, you want to deploy the technology, the algorithms that you have trained now. You want to deploy those to recognize people, to identify people. And again, I guess we have to distinguish between general personality rights and the GDPR. Let's start with the general personality rights. Again, they're defined on a national level. And they go far beyond, in many jurisdictions, or I have to say in most jurisdictions, they go far beyond what the US recognizes as a commercial right to publicity. It safeguards your personality. These personality rights are intended to prevent a constant surveillance. They're designed to protect your autonomy. And so that makes it much harder to deploy facial recognition software on a large scale, because what would you need to do? You would need to surveil public places in order to identify people, at least if that is the way you want to use the technology. But that surveillance of public places, that is exactly what's strictly limited. Both to protect your non-commercial autonomy, as well as to protect your commercial interest in your own picture. Let's move to the GDPR. Just recall, as soon as you have personal data and that personal data is being processed, the GDPR kicks in. You inevitably at that stage have personal data. Why is that? Well, because the entire process is about identifying people that you see somewhere on a video, meaning the process is designed to put together, to connect a picture with an identity of a person. And as soon as you engage in that, as soon as you create that connection, you're inevitably within the scope of the GDPR. Again, there's then a general prohibition on engaging in that conduct, on processing personal information. And the question again becomes, do you have a justification for doing so? You need to look into Article 6 and then potentially Article 9, which provides that heightened threshold. And let's pick out one example where we have already a ruling from a data protection authority within the EU. That's consent. So let's assume that you're an entity that wants to use that technology. I've heard the example with the bar exam earlier on. So the bar exam asks for your consent, for your permission to do so. And that's what a school in Sweden tried to do. They said, well, we want to check attendance, and we want to check attendance automatically by using facial recognition software. And they got the consent from all the students or their parents respectively, of course, acting on behalf of the students. And the Swedish Data Protection Authority said, well, that's not possible. Why is that not possible? Because that doesn't live up to the threshold that is set for consent. Consent is there to ensure real autonomy. The Swedish Data Protection Authority said, well, those students or their parents respectively, they're not acting upon real autonomy because there is a clear imbalance of power between that school, or it was the local municipality that ran the school, and the students. The students didn't have a free choice if the school asks them to give permission to use facial recognition software in order to check on their attendance. What other choice do they have? Do they want to be singled out? Do they maybe get written up just because they opt out? We don't know that, but we know that there is a clear imbalance. The case ended with the Data Protection Authority in Sweden fining the municipality in question 20,000 euros, which is around $22,000. I want to pick out one other thing before I conclude. I see I'm already at the end of my slot, and that's Clearview. And that brings in one additional layer in terms of what you have to look at with respect to the GDPR. Now, Clearview is an American company, and as far as I know, they do their data processing within the United States, which means that if a German entity, whether it is a private entity or a state entity, wanted to use Clearview's services, they would not only need to adhere to the protection of personality rights on a national level, and the GDPR on an EU level, they would need some sort of justification, as we have discussed. They would also need an additional justification for the transfer of the data outside of the Union. They would need to adhere to the framework that the GDPR set up for the transatlantic exchange of data. And since the European Court of Justice for the second time invalidated the general agreement between the EU and the US when it comes to the transatlantic exchange of data, they would need to rely on so-called standardized clauses that then would govern the data exchange. And that adds a probably a third level of protection for EU citizens when it comes to the processing of their data. I see I'm at the end. I'm more than happy to answer any question. I see one question. Let me grab that before we move on. So Tamara asks, so does Sweden not hold by consent in generally assume any company has a higher hand? Okay. The consent framework also applies in Sweden. Yes, it does. Yes, one can assume that there are many companies that hold an imbalance of power over their customers. That said, not every type of consent that a company tries to get from its customers is invalid because of that imbalance of power. We have to, on an individual case, make an assessment how egregious this imbalance of power is. And when it comes to the relationship between a school and their students, the imbalance of power is incredible, right? The school can grade you, the school can expel you, the school is, depending on the jurisdiction, you don't have a choice whether you want to attend that school or not. So the imbalance of power is just much greater than it is, than the imbalance of power might be between you and, let's say, some local business that collects your data and wants your permission to use facial recognition software to surveil whether or not you correctly use the laundromat. I hope this, like the difference here becomes clear. So with that, again, thank you so much for having me. If there are any further questions, please feel free to bring them up later or reach out to me anytime. I'll post my email here in the chat, and back to Shlomit.
Thank you, Nate. It was really fascinating to study more, not just about GDPR and Euro, but also to hear about specific cases. Yeah, I wonder, just when in not just, but like a few months ago to Amazon store by the Fifth Avenue, and they have like this recognition system where you don't have to pay and you just take things and go out and they charge you. And I wonder, would it be a consent? Like, but let's leave it to the Q&A. And we have some other questions that will, follow. But I think let's move to our next speaker. And I think one critical thing that, because I come from the legal regime, and usually we discuss with lawyers and professors of law. And I think one of the main problems that puts a lot of hurdles to the legislator and policymakers and regulation in general is the missing dialogue, I think, between the industry and policymakers, and especially, and I think the misunderstanding of how these technology work. You know, in the ISP and fields and CLIP, we are trying to kind of like bridge this gap, but I thought it's really important to bring the voice of the industry, and Any Vision, A Better Tomorrow is a very interesting, I would say, company that deals with it, develop facial recognition based on artificial intelligence system. And we have Mr. Enrico Montagnino, the vice president of Any Vision, who was actually, who's graduated from in computer science from Kingston University in London. And he will be presenting about different perspective about like how can it be fair, and I think that the industry themselves, they struggle. They really want more regulation to be more like to work in a safe environment. So I just find, so Enrico, thank you so much for joining us. And I'm just trying to find you and to make you okay, yeah, he's here with us, and really like he's the vice president for very international, well-known company. And yeah, so the floor is yours, and you can also, because you're a co-host, so you can share your presentation. I'm really thankful, because this is what we miss in our legal environment.
Absolutely. So good afternoon, good morning, everyone, or good evening. Thanks for the invitation today. Can you guys see my slides?
Yeah, perfectly.
Let me just put them into presentation mode.
All right.
You see it?
Yeah, great.
Excellent, brilliant. So yeah, guys, thank you very much for your time today. I'm dialing in from London, or from lockdown London, as I'm sure most of you now probably have seen in the media. We're experiencing the new wave of the new corona virus. So we've become the enemy of the world at the moment, and I think we're banned from about 40 different countries. So it's nice to be speaking to you guys from different parts of the US, as I understand it. So I just picked up the last couple of things that you were saying there, Nicholas, and you know, it's a very interesting debate, because, you know, facial recognition is, you know, it's probably fair to say it's a bit of a hot potato at the moment, and there's so many different misconceptions out there in terms of what it is, how it works, and you know, how, I suppose, scary it is. And it's probably fair to say that the subject around data protection, it's so broad and encapsulates so many different technologies. What I find is that when I talk to customers, they kind of put everything into the same bucket. So facial recognition is the same as everything else that you read in the media about, you know, the big Googles and Amazon taking your data and listening to your calls and using that data against you, or maybe using it for kind of marketing purposes. And it's all muddled up into the same mold. And you know, coming from the security industry myself, and, you know, dealing with different types of analytics, and then latterly coming into, you know, facial recognition, you know, it's very, very tailored in terms of how it can be used and how it can be controlled, and making sure that only the, you know, the right people and only the right uses or use cases are executed. And when people actually understand how it works, I had a little voice pop into my ear there. But yeah, essentially, when you understand it in a little bit more detail, people are actually calmer with the fact of, you know, the use of this type of technology. And I'll share with you a couple of things that, you know, I'm seeing in other parts of the world, and how, from a regulation perspective, some local authorities are now allowing the use of facial recognition, again, in very, very specific use cases where there is a value, which, you know, is either to protect, for safety and security purposes, the general public or people within a certain environment, or actually in other cases, it's, you know, it's to provide an enhanced level of service, which actually in some verticals, in some customers, does provide great value. And when people understand what that is, again, they do enroll to these types of technologies because it makes their lives easier in some cases. And again, I'll give you a couple of examples. So my name, as I said, Enrico. I'm the VP of one of our sales regions, and I've been with the business for about 2 years. As I said, I come from this industry, and what I wanted to do in the next couple of slides is just to kind of build a perspective of what we believe are the building blocks of, you know, what a safe facial recognition platform should be, and what we do as a vendor, just to give you an insight to understand what steps we take. And just finally, I want to share with you, you know, what we're doing with the ECCV, which is the European Council for Computer Vision, to really throw the subject out to the public domain, academics, vendors, and say, you know, prove that your algorithms do meet the standards that the industry asks for, so that we can start to put a demarcation between the many vendors that are in some cases biased or use, you know, algorithms that are not fair, to those that, you know, are investing in making sure that their algorithms are non-biased and fair, so that, you know, customers and the industry generally can understand who is investing in this, and you know, which essentially vendors to trust. So just to put this into perspective, you know, again, I mentioned the word hot potato. It's probably fair to say there are many international you know, incidents and events that are going on, like the BLM, which is a great movement, which has brought forward the subject around not just facial recognition, but generally the use of, you know, different visual technologies or computer vision technologies to identify people, track people, and for good reasons. You know, people are asking the questions about, you know, the application of them, what regulation there is, what kind of frameworks that can be used around. And the reason why I say that's good is because up until now, from the industry perspective, it's actually been very challenging, because when we go into different countries, it's not regulated, and there isn't really any frameworks, and there isn't really any you know, ways for us to prove how our technology is, you know, safe. And what this is now doing, such as BLM, is pushing that to the forefront, and we're starting to see some, you know, light at the end of the tunnel. Interestingly, some of the biggest vendors in the world, or I say vendors, some of the biggest IT companies in the world, like IBM, Microsoft, and Amazon, have kind of moved away from it for reasons which I you know, personally, and of course I'm going to say this coming from the industry, I don't agree with, because it's a very reactionary step in terms of, we're just not going to use facial recognition anymore, without really looking into and understanding how it can be used, and you know, essentially looking at why they started their journey originally, which, you know, there was a real value with facial recognition, but now, because there's been a media or, you know, different types of media attention, they've just decided to kind of throw it away. As Anyvision, we see that differently. We believe that facial recognition is here to stay. We're seeing many different you know, shoots of light in different countries, where there are frameworks being built, there are values that are you know, are being used by different customers, and that's now starting to grow. And again, that's not starting to grow from the point of view that it's, you know, it's going out of control, but it's forcing the question of how this technology can be used, and these little small shoots is now growing into more and more customers in, you know, in different respective countries, because they can see from others what the value is of this technology, and you know, ultimately how it can help them. So, as I said, you know, what the these small shoots of light in our industry is now starting to do is really bring the whole debate and question about providing a legal framework around facial recognition. And in some countries, that's now starting to come to light. Again, for those of you that or for those of you that have kind of followed this as a subject, there are different countries now that are using the technology. There are different countries now that are now starting to put frameworks around it. So, for example, in the UK, which is where I live, the Met Police, which is one of the biggest forces in the UK in London, run some trials on this technology, which is now being basically approved by government to be used in very specific use cases and specific kind of situations. And now we're in the kind of next phase of government allowing that, and the police now writing a framework by where the public will be very clearly presented to in terms of how this is being used, where this is being used, within the very strict rules and regulations. Outside of the UK, I've been involved in a project in Spain where a big retailer has worked with the local regulator to build essentially a legal framework where the basis of them being allowed to use facial recognition is very, very strict. And just to give you an example, somebody's face can only be enrolled onto a watch list, which is basically what's the term used to put someone onto the system, only after A, they've been found stealing, 2, they've gone to court, 3, a judge has prosecuted that person, and 4, where the judge has actually stated a period by where they're not allowed to go into that retailer. So using those 4 steps, we've built a system around them. So in other words, again, we can't put someone on just because we want to. It has to be someone's been prosecuted by a judge, or has gone to court and prosecuted by a judge, and where the judge has said that they're not allowed to go into that store or chain of stores for a particular period. So there are many, many more examples, but again, we're now starting to see the mold of where this technology can be used, and where the regulator is coming into the picture to put that framework around it. So our mission, I'm not going to read this, is clear there, but essentially, we are a leader in this market, and we believe that computer vision can be used in a safe and secure manner. We leverage the latest in machine learning and AI to make, in our opinion, the world a safer place. And at the core of our building blocks is that we have ethics, privacy, and data integrity as the 3 main things that we ensure that we build into our platform, we maintain with our customers, so that the fear of my picture is going to be stolen or people are going to look at who I am without my permission is addressed. And I'll give you some examples exactly how that's done. So in our opinion, there are 5 indicators that make a facial recognition technology ethical and unbiased. So these are just the standards that we believe, or the 5 indicators of what every vendor should follow. One is that you need to use diverse data sets. So for those of you that are or kind of familiar how these technology work, is that essentially we teach our system to look for specific things. So we use diverse data sets from race, ethnicity, age, gender, etc. So the system does not bias one over another in terms of ethnicity or age or race. So that's the key to what I say the number one, most important thing. And obviously, particularly with the recent unfortunate COVID spread around the world, the use of face masks and face coverings has now become legal, legislated in most countries. So we've had to ensure that these technologies can also take into account the use of face coverings and masks, so that we can ensure that we can still, detect and recognize the right person without being biased towards, any of the above race, age, etc. Second thing is the biased factor. So I touched on it before. Biased is probably one of the biggest debates at the moment, as I mentioned, with some of the things that are going on in the world at the moment, and I mentioned some at the start. People are concerned that these technologies are biased and they're going to be prejudiced to towards a certain race, for example. And it's imperative that when we build it, or any vendor builds any systems up, it has to be very broad in terms of what it looks at and how it teaches its system, so that when it goes into specific environments, it's not biased. And again, I'll give you a couple of examples of what we're doing and what the industry are doing. Third is privacy. So it's imperative that we ensure that we, not just we, but different vendors maintain the integrity of people. So for people that are not on a watch list that the system doesn't pick up, for people that do not want their picture to be enrolled, it's not enrolled, and to use the latest in mathematical vectors, or when I say mathematical vectors is what we use, to ensure that when we put someone into a system, it's not a picture, it's not someone that can look at and associate with straight away. It's essentially a set of numbers. And again, I'll touch that in a little bit more detail later. So it's ultimately about ensuring that only the people that are legitimately allowed to be on that list are on that list, and anybody else outside of it have either their face blurred or their data deleted, or that we put specific retention times in terms of how much or how long the data that is captured by us is kept in the system. And these are, I would say, standard tools, but are very important tools, because it does, when you start to use it, give the people the black and white facts about how can you ensure that my picture is not seen? How can you ensure that my data is or my picture that was captured on CCTV is not stored on your system for longer than 24 hours, 12 hours, or whatever it is? And again, these are one of the building blocks of what my systems need to have. It then also is down to the ethics framework. So who do you sell to? Where, which countries do you sell to? For what specific use case is this technology being used? And we as a vendor have a obligation to ensure that we don't just sell it to anyone. We ensure that there is legitimate reason for the technology being used, because if you think about it, if we just sell it to anyone, we're putting our own reputation on the line, and generally all we're doing is we're fueling the fire in terms of the bad interpretation or perception of what facial recognition is and how it works. So we're trying to change that. We're trying to educate the market by demonstrating what we're doing and what the industry is doing to make it fair and non-biased. So again, a key aspect of that is to ensure that we sell to people that are not going to take this technology and use it in a way that would essentially fuel the fire in terms of the debate of whether facial recognition is safe or not. Lastly, it's kind of linked to the one before. Again, it's about ensuring that the technology is not misused. It's not used in environments where people are randomly looking for individuals without legitimate reason, without reason of either safety or security, or for enhancement of a service. And again, it's our obligation, not just as AnyVision, but as the industry, to ensure that that is maintained for the reasons that I've already mentioned. So just to drill down into what we're doing as a vendor, okay? So again, we have our own building blocks in terms of what do we do to address the 5 points that I mentioned above. So firstly, what do we do to make sure AnyVision products are being used fairly and ethically? So number one is that we adhere to our own ethical code. So meaning that we don't sell to certain countries that do not have respect or do not believe in the privacy or the rights of individuals, where technology has been in the past, in history, being used against the general public. That is a complete no-no for us. So everyone that we sell to is vetted, whether that's directly to the customer, whether that's through what we call a channel. All of those are vetted to ensure that we give the green light before our technology touches any other hands. Two is we train our algorithms based on a very broad and fair data set. So like I said, the data that we use is broad against different ethnic backgrounds, races, genders, ages, so that when the system is looking for people, it has a balanced view, and it's not biased towards one race over another. Different vendors that I've come across from different parts of the world, the data sets that they use are based on the race in where that country or where that vendor's country of origin is. So with 80% of that race being used as a data set, their technology is very biased. And we've seen that in different kind of shoot-offs that we've been involved in. So we make sure that ours is very balanced across the different data sets. Two, which is a very important very important point, is that our algorithms are developed by professionals, and all those professionals do come from different nationalities and races, which is another safeguard to ensure that not only is the data set fair, but those that are basically using and building our platforms do have a diverse background, so ensure that they are not being biased towards what the system is learning, and ensuring that the technology is very, very fair across different facets, and by bringing their own background to the table. Again, we find that very useful, and another kind of layer of assurance that it is fair and also ethical. So in terms of the integrity of the people, so I kind of touched on this. So in our platform, very specifically, we ensure that those that are not enrolled on a database or on a list do not get seen by any operator or by any user of a system. So for the concerns of people saying, oh, my picture is going to be seen by someone and I don't want my picture in the system, we can ensure that only those that are on the list are seen, and anybody else, it's basically noise. In other words, we completely ignore them, and they are kind of deleted from the system. If there's video that's downloaded for evidential purposes or it's being used for any other purpose, when the video is replayed, we build blurring into the scene, so that, for example, if I'm the person on the watch list, I'm found, the video is replayed, and my picture of my face is shown, anyone else around me will be blurred automatically. So there's no concern that, oh, you've got the video recorded and now you're going to see my face, even though we don't know who you are, or actually you've not even been captured. We still add that layer to ensure that a person's face is completely blurred, hence the ensuring the integrity of that person. One thing we do is from the educational perspective, we run different sessions proactively. And when I say sessions, sorry, I mean training sessions to our users about how this technology can be used, how we adhere to certain standards, and what we believe our customers should also do, to ensure that both from a technical and also from an operational perspective, what the operators should do and not do, and from a technical perspective, how the system could be tweaked to ensure that it's very specific about who it's looking for, or in what areas the technology is scanning to find a person or different kind of people. So that's the building blocks of what we do and how we address the 5 pillars as I presented before. Now, one of the things that we've done proactively is that it's very easy to say, yes, we're non-biased, and yes, we use this data set and that data set, but we set ourselves a challenge. So we approached the ECCV, which is the European Council for Computer Vision, and we sponsored a small project where we basically put the challenge to the industry, both to academics and also to vendors, and set or provided a data set with different backgrounds, different ages, different ethnic backgrounds, different races, and basically said, guys, show us what you can do. Show us if you're biased or non-biased. Show us if you're fair or not fair. Not that they wanted to show us obviously if they weren't fair, but but show us how your system does adhere to these standards. Now, the reason why we did this is, one, because we want to be proactive. Two, is we want to show the industry, look, we're not scared here. We're not hiding anything, and we know that our technology and this facial recognition market is safe. If it's legislated properly, if it uses the right technology, you can use it, and people's integrity can be maintained. And with the strict guidelines, this could be used to the benefit of all of us. In some cases, to stop bad people from entering countries. B, in good cases, to give you a better experience in terms of entering a building, providing a different layer of security above and beyond the card. So, for example, one of the things that we see as quite a growing trend is the use of facial recognition for access control. So, imagine a world where you didn't need a card, or you didn't need to enter a keypad, and you just use your face. Now, in my opinion, I don't see that being contentious in any way. It's an opt-in or opt-out. But of all the places that we've been in, countries that are very, very sensitive to data protection, the benefits massively outweigh the negative aspects. And in most organizations that are now using this, there's like a 98% opt-in and a very, very small percentage of people that are opting out. Because, again, it's very strict in the way that it can be used, and there's a huge benefit that it can bring to the general public. And in this case, access control is just one of the examples. So with ECCV, the challenge was to basically provide results on what we call one-to-one facial recognition or facial verification. We provided a data set in the wild, which basically means from different cameras, different angles, different lighting conditions, of around 12,500 different images with different aspects or annotations from gender, skin color, etc. And the net result of it was that 151 participants entered. There were 18,000 submissions, and of the top 10, and this is again going through the results very quickly, the top 10 exceeded basically 99.9% accuracy, which was a fantastic result for us. Not just because we know that what we're saying is true, but there is an industry there, and there are many different players. Whether we see them as competitors or not, this is not about selling. This is about proving and challenging those that don't believe in facial recognition to say, guys, we're funding something to show you, and here's the data, not just from the vendor side, but also from the academics, that if it's used properly and the right technologies are applied, this is very accurate. It's not biased, and it's there basically, as I like to say, proof in the pudding for everyone to see. And this data and these results are available if you go to the ECCV website, and it's just a kind of a proactive move from us as a vendor to address, as I said, what is in my opinion, the wrong perception of what facial recognition today. As I've already said, this to me shows and to different people that I've been talking to in the industry that have been skeptical, that have been scared to take the step into facial recognition, have now seen why what I'm saying is true in terms of, guys, we are accurate. The industry with the right vendors are accurate. That the data that we use is non-biased. That we ensure the integrity of the data is maintained, and this is what I would say is proof in the pudding. So, in summary, I only had 25 minutes. For me, and for what I'm seeing from the industry, facial recognition is here to stay. Facial recognition is not a scary subject. It's a technology as different and other forms of biometrics, which, if used in the right way, can provide significant value, not only to us as individuals for our own day-to-day lives, from taking money out of a cash machine to entering a building, to ensuring that those that shouldn't enter certain areas do not, to real national critical national surveillance type subjects, where we ensure, or this technology can ensure, that the wrong people don't enter the borders, that the people that are in country are spotted and taken off the streets as quickly as possible, because it's about our own safety and our own surveillance. And just to finish, to put this all into perspective, guys, is that we live in a world where there are thousands and thousands and thousands of cameras, in fact millions of cameras, that are today capturing us in terms of what we're doing. Okay, and we can't get away from that. And behind those cameras there is operators that look at a screen and basically make judgments based on what they think, and nobody's questioning about them being biased or how they're making their decision. And what facial recognition is doing is providing a layer of automation using the latest in AI and machine learning to provide a much more fair and accurate kind of decision-making process as to finding the person in the many thousands, many millions of cameras that are capturing us anyway, and giving the right people access to the right information to make our lives safer or to make our lives better. So I just wanted to share that with you. It's been a pleasure, and if I have some time, I'm more than happy to take some questions.
Yeah. Okay. So thank you so much, Enrico. It was fascinating. I think from, not just from the industry point of view, but just from academic, because we always ask the question, so who becomes the regulator when there is none? And there are several questions, and I see that, like the fact that the industry themselves, like AnyVision is one example, that become like a self-regulator because you feel like you need a regulation, and it's really fascinating. Some people wrote, like in Harvard Law Review, that it became like the insurance company are the one to decide, and I think it's really amazing. I just want to say that it might be the controversial or the dispute between law and economics approach represented by Richard Posner that said that we give up privacy for cheap, and we already use it in medical and banking and remote communication as you described, which was really interesting. Or just for a coupon, and then we say, yeah, we want our privacy back. And actually, you also say that like in the digital era where the advanced technology develops so rapidly, so we cannot really have any privacy. Versus the personality approach, which is more dominant in Europe, that say that like personality is something that belongs to the person, and there are still open questions. What is this data in our face? I mean, is it our property or is it just data? And what is your role? The industry, do you have fiduciary right toward us or any other right? I think there are a lot of open questions that you raise, and I think it was really fascinating. So we'll open the floor for questions. Stephen, the representative of the Fordham IP Law Journal, which is a great one. They just rapidly jumped to the first one in its field. So Stephen, you can just present some of the questions to all the speakers, and we'll take these 10 minutes before we'll conclude and go on with a limited session for a new research about this topic.
Okay, thank you, Professor. There were several questions for the speakers. The first one was from Ms. Ziva Hode, and that was regarding the issue of technology advancing too quickly, I think specifically in America, where legislature and the courts can't keep up with the developing technologies. And so she wanted to ask if there is a solution, any sort of proposed solution that would slow down the development of technology to allow legislature to prepare appropriate laws to address them. And I guess if so, would that help the issue of courts keeping up with technology?
Maybe yeah, okay.
Is that to me?
I think perhaps Patricia might. It was more of Patricia's.
Yeah, I'm happy to take it. So I framed that as a problem from the law side, but of course, I think we all agree that it's not a problem from the technology side, right? So we want to spur innovation. Our entire, intellectual property foundation and our economy is based on innovation. So we are more than delighted on one hand to have this innovation and to be a hub for this innovation, but sometimes inevitably too slowly because, the wheels of legislation take time. There's politics involved. And also, as the Supreme Court said in one early case on the digital world, they said, we're not ready yet. We don't know what this world is going to look like. And they don't want to make laws. And the rule number one in lawmaking is don't make the law for the problem you have today. And the thing is that the problem you have today moves very fast when you have a technology that develops so rapidly. So I wouldn't frame it as a societal problem. I think it's just the law does react quite slowly.
Maybe we'll hear the other speakers, what their opinion on this question, and we'll move to the next one.
If I may, just from my point of view, I mean, I don't believe facial recognition has advanced that much that the courts can't keep up. I think what it does and where it's been the same for quite a while. I think the only enhancements that you've seen is that it's become more accurate and it's become less biased. But in terms of running away and getting overzealous with what it does, it's not. There's no vendor that I'm aware of that is kind of taking it to a step that really does look at much more than the face or looking at more in-depth information. It kind of stayed where it is. It's improved in terms of its quality. And in my opinion, I don't think that there's anything that the industry is doing that's outpacing the courts in terms of how they would review a case where facial recognition is used or where a regulator would put a framework around it. I think it's been out in the industry for so long now, and it will be for a long time coming. And the only advancements I think you'll see before it's adopted in the mainstream is that it will just become more accurate. And I don't think that's a reason for it to kind of outpace the courts.
Yeah, I mean, would it be correct to say that what you're doing is more like facial matching than like the Chinese social reform example of facial recognition in general, or am I wrong?
Facial matching, facial recognition. I mean, it depends who you ask. That's kind of the same thing. What we're doing is that we are, number one, ensuring that before anybody's enrolled onto a database, that there's a legitimate reason to do that. Number two, that we ensure that we frame our technology or our platform so that only those people are relevant to us and anybody else of it is just noise. And then number three is ensuring that the quality of our algorithm that ensures that when we find that person, we're as sure can be that Rico is Rico, or that John is John, regardless of his age or her ethnic background, so that we don't find someone that's not that person, which obviously, unfortunately, we've seen in different cases in the media where different facial recognition technologies have been used. But back to your point, facial matching and facial recognition is one of the same thing. Again, different use cases. There is what's called one-to-one, which is kind of passport control, which is more what probably is face matching, and face recognition is more public space in the wild, kind of CCTV surveillance, like a state or a city where you have many hundreds of cameras. They're capturing different phases in different environments, and that's more face recognition.
I see. Do you think it's feasible to acknowledge all the people that their faces are being taken and swallowed by the AI system? Because that's one of the policymakers, like just to make me, like if my face was taken and processed, I want to know, and maybe I would like to delete it according to the GDPR. And I wonder what Nick is also think about that.
Again, great question. I mean, and it's one that I've get asked quite a lot from different people in different countries. And the first thing I say is that we don't take your face. We take an image that's been recorded of you anyway. So it's not like we're proactively putting devices out there that, take information about you without you knowing, because as I said, we work off the back of surveillance systems that are already in operation, which by the way, have already got your picture and they're storing it for 30 days. So we use that information. And then what we extract from that information, as I said, is in essence a vector, mathematical vector. It's not even the image itself, it's just a number. And that's how our technology works. So again, this is the misconception that I find with facial recognition, is that when you say it, facial recognition, people get alarmed that somebody somewhere is putting surveillance devices out there and it's capturing my face and it's being processed. And you know what, even if your face was processed, okay, in the worst case scenario, which again, we don't know who you are. We don't know where you live. We don't know anything about you. It's just an image. And an image to us means nothing unless you process that and we know who you are, which again is where I feel when you have, the whole subject around what Google's doing and Amazon are doing in terms of listening to your calls, taking your personal information and using it for their own benefit. That's when I'm also on the same page that we do need to very strictly regulate how data is being used. But in terms of facial recognition, unlike the Googles and the Amazons, we don't know who you are. We don't know anything about you. It's just an image that's being processed anyway.
But it can be like, and how can we make sure, you can make sure that it's not transferable to, to some entities that can make a malicious use of this data, like, governmental.
Great question. So, yeah, so it's basically to conform to the same, IT, cyber and security standards that any application that's being used today conforms to. And what that means is that, like any software platform, whether you're a government entity or a private entity, your platforms have to adhere to certain security standards in terms of where the data is stored, for how long the data is stored, who has permissible access to that data, et cetera, et cetera. So what we do is we provide the tool to, let's say, the government entity, and then they put it into a quarantine, which is, by the way, exactly the same place where they use applications for other purposes, and using those same standards, they can ensure that your data doesn't get in the hands of someone else, or that we as a vendor can access that data and use it against that purpose. Use it against that person.
Okay, wow. Nick, I guess it would be interesting to hear what
yeah, more than happy to add a bit on that. So I want to add two things. So one, I think it misses a point if we say that this does not mean additional surveillance, and that is because the more potent you make a surveillance technology, the more incentives you create to install additional surveillance. The existing surveillance without any analytical technology, whether that is face recognition or whether those are other techniques, is basically limited by scale. So if you go back far enough and look at the first types of video recording of public spaces that we had, those were very much limited back in the day by the storage capacity of those devices, and they were limited because you need people to look at that stuff. That's expensive. And the further you develop analytical technology and deploy analytical technology, you make that surveillance cheaper and you make it more attractive. That's the very selling point of any sort of analytical technology, whether that is facial recognition or whether that is anything else. So I think we have to take into consideration that there is a feedback loop between how much surveillance you see in the public space, how frequently you are surveilled, and the availability of that technology. So I think that very much goes hand in hand. On the my second point is on the accuracy. So there is, I think there are good arguments why accurate technology is better and less intrusive than inaccurate technology. One reason is bias, where we might think that we can reduce bias by more accuracy. The other one is simply avoiding unintended fallout. We don't want to accuse somebody of a crime or being in a certain place or having done a certain thing or not having been to school or like not showing up at the bar exam because that person was misidentified. Point very well taken. Now, the problem is accuracy is a two-edged sword. So if you're not concerned about misidentification, but if you're concerned about surveillance in general, and if you believe that mass surveillance is a problem for individuals, for autonomy, or simply to society as a whole, then increased accuracy actually makes the thing worse. Why? Because it makes the thing better. It makes the thing more potent. Meaning if you are somebody who is concerned about being identified in the street for whatever reason, maybe it's your personal preference, maybe you're running from something, maybe you feel politically oppressed, whatever it is, a more potent, more accurate technology is from that perspective bad to you. The second sub-point, and that's on bias, is that increased accuracy does not necessarily mean that we reduce bias in systems at all. To a certain extent, increased accuracy means that we increase bias in the term of the type of self-perpetuating discrimination. Why is that? It depends on what we understand to be bias. If you understand to be bias only that a person is misjudged by some category in which that is deliberately included in the decision-making process, that's a very narrow definition of bias, then indeed accuracy can reduce that sort of bias. If your concern is more of a structural nature, then increasing the accuracy of a prediction tool can actually make that type of bias worse. Why? Because an increase in accuracy of a prediction tool allows for more granular differentiation and more granular discrimination. And as we know, any sort of feature that we pick has connections to protected characteristics, whether that is political orientation, sexual orientation, ethnical background, racial background, national origin, whatever it is, you find those characteristics are reflected in other features that are not protected. So whatever we sort for, and the more accurately we sort for other characteristics in tools that are deployed to the masses, the more we run into potential bias problems and discrimination problems. I'll leave it with that. Thank you.
Very interesting. Stephen, are there more questions to be raised? Maybe you'll put them like all in a row, and then we can.
Yeah, I could present. There's several more questions. I could try to boil them down to some short points. One was from Tzvi, which asked that there is like uniformity in world-class companies and preservation of security information in banking, communications, and things like that. And why is there no such global regulation yet for this field, with information privacy technology issues becoming the forefront of concern for a lot of people? So that was one question. Another question was from Danny, and he's asking where the law would stand on, because a lot of the focus has been on facial recognition and use of AI in the government context, but not so much in the reverse. And he was pointing to recent developments in Belarus, which consisted of citizens using facial recognition against the police. So where police would attack, or not attack, but would beat up or arrest rioters while wearing face coverings. And then citizens would use facial recognition AI software to uncover their faces digitally and figure out who the police officers were, even though their faces were mostly covered. And he wanted to know where the laws would stand on that and how they would go about addressing it. After that, there was another question from Mathew Rubenstein, which was, as far as coming up with policies and laws that address these issues, how would we know what systems are we using to monitor the companies and the government entities that are using private data? So meaning more of a, I guess, a general sense of how do we even know if people are infringing on it, if they keep it secret or hidden from us, and what sort of guidelines are being put in place to prevent that hidden use. And then the second part to that was how are violators of the GDPR being caught, being monitored, how are they caught, and then when they're caught, how are they punished? I think other than that, that was most of the questions.
I think we'll end, yeah, we'll just take like one speaker after the other because we have to conclude this session, which is really interesting. And then like everyone can pick whatever question he would like to answer. And he has answers because we don't have answers for all of, obviously. So maybe we'll start with Professor Brez, Patricia. Okay, we lost her. So Nick, maybe she will be back. Yeah, so any question you would like to answer just to conclude this session?
Oh, sure. I'm happy to pick up on one on the question why we don't see more international regulation or like an international approach to that. I think the question to that is simply that our values that underlie those decisions in privacy, data protection, but also our willingness to invest in new technologies, whether that is facial recognition or whether those are other potentially privacy invasive technologies, is simply so different that I don't see room for an international consensus or evolving around that. And just adding to that, and that is probably a more general point about international agreements at the moment, is that there just doesn't seem to be the political climate for enforceable international norms.
All right. Enrico, would you like to pick one of the questions? Enrico, we lost him. I felt like okay, so they said it's not letting people unmute, so let me correct that. Something happened, but I should be, one moment. Okay. Okay, so you can unmute yourself, I think, now.
Yes, I'm back. Sorry, I couldn't unmute. I'm happy to take the question about where does the law stand in using it against the oppressor, if you will. And well, really, right now, since we have no legislation that regulates how really the police use it or how private entities use it, there's also no regulation against how private citizens use it. And just like I showed you all the pictures of the interesting makeup and contraptions and glasses and masks that people come up with, people in their own ingenuity have also come up with ways to use facial recognition against Big Brother if you will. There's an Italian artist that you can look him up. I think the last name is Sirio, who has done a huge installation in France. And he has taken pictures of all kinds of protests around the world of the actual policemen in the protest and enlarged those pictures and kind of in an artistic way used facial recognition to identify or also, you know, to see the faces or to out, if you will, the police. Also recently, I think I mentioned that, I think it was Detroit, the police was talking about banning facial recognition. They ended up not banning it. They ended up saying that it was okay. But one of the, and this was very well publicized, one of the objectors was a citizen who himself was a coder and said, I found out a way to use facial recognition back on the police, and you really can't, you shouldn't stop my own research. So I think really, if anything, this makes the point, 2 points. One, that there's no regulation here. And two is that the regulation, if and when it comes, it cannot be a black or white thing. We're not talking about vilifying a technology. Technology is neutral, right? It's the uses, it's the context, it's the audience, it's the location, it's the places that it is used and how it is used that need to be sliced and diced in the legislation to carve out, you know, reasonable protest and things like that. So I'm happy to take that question and happy to have one of my fellow panelists take the last one. Thank you.
Right, so we lost Enrico, so maybe Nick and just conclude in one question and also Patricia, and we'll move to,
Please remind me what the remaining question was again.
The Stephen's role.
Which one was still open?
This was how do violators get caught?
Yeah, the one you answered, I think, in the chat is interesting. Like using facial recognition against policemen.
Oh, okay. Yes. So I'm just aware of this recent French. Hello.
And yeah, we'll.
I'm just aware of this recent French initiative that limited the ability, or was intended to limit the ability to take photographs and pictures of police, which was, I guess, would be one limitation on using this technology as well against police forces. The other thing is, I'm always a bit cautious when one places too much hope in employing technical means in changing asymmetries of power. And that is because technical means are mainly defined by the resources that you have. And so if you are willing to enter into an arms race with either an oppressive state or a state that you perceive to be oppressive, or companies, as an individual or as civil society, you will almost inevitably lose. That is not to say that there are exceptions to that. There certainly are exceptions. And the example that was brought up in the question is potentially one of those exceptions. But I would be very, very cautious to generalize that in any way.
Patricia, do you want to say some concluding words? And
I think the last question was also, how do we monitor companies and how do we know if it is in use? I mean, I think the short answer to that is we don't, and that's why we're concerned. And you know, notice and consent is one thing that I mentioned, but even when there's notice and consent, we know that that's often not enough. So, I mean, I think this is going to have to be a conversation that's going to have to happen rapidly, but with kind of future proofing thoughts. And it's going to have to happen collaboratively within communities. There are cultural constraints here as well, national ones. And I thank you for introducing this conversation because it's a very important one.
Yeah. Okay, so yeah, we will conclude this session. We tried in a short time to bring the issues, the challenges, the privacy, the biases, to bring the US perspective versus the European perspective and the industry, which is, I think, really important one. And I think bridging between the industry and policymakers is one of the main goals that should target regulation. And I think it's being done recently. But as a representative of the academic world, I think what's interesting and fascinating is that we just start the journey. And the next step will be to present ideas and solutions. And as you said, like trying to deal with the challenges with new solutions and new models and using the theoretical justification in the right way. We just have heard from Bolton, the professor at Yale, the head of the ISP, about fiduciary rights, and then we heard an example from Enrico from AnyVision about what does it mean to be fiduciary from their perspective. But I think it raised a lot of questions that are unsolved, and like what is a fiduciary right, and what should be done, and what can be done. When we understand the technology, the challenges become much more difficult and more complicated. So I want to thank all the speakers until now, and to conclude this session, if you would like to go on listening, I mean, whoever we said it will be this, I know in Zoom we cannot really stretch the time too much because it's still, it's a digital and unlike a real conference where we can stay 2 days and with breaks and food and chats and some relaxation and cultural events. So I want to thank everyone, and whoever liked to stay and to hear some of the one of the researchers. It's about a new research about the challenges and new solutions in respect to facial recognition. You're most than welcome to stay, and whoever has other plans. And I know I see here people from India, from Israel, from the US, and also in the US, I mean, there is a vast, like from California and New York and mid state, and so in Miami, of course, and so Boston. So whoever has other things to do, we are really thankful. I think it was fascinating discussion. I wish Joel, I'm keep on changing the, my background. So I wish Joel was here to listen and to contribute something to the discussion. But I think if he would be here with his smile, as you can see behind me, he would be very happy and satisfied from bringing this discussion into the table and trying to further develop the academic discourse. So we are welcome. Now I turn the ball into your hand, and it's your turn to write academic scholarly articles, to suggest solutions, and to bring new ideas to the table, which will influence. So it's you guys, the students and the scholars that are have the ball in your hands to promote the discussion. So thank you very much. And we'll continue to the next researcher that present a brand new research about facial recognition, Miss Yasmin Al-Umari. And she will present right away. The floor is yours. Whoever wants to stay is more than welcome. And whoever needs other things, so we are thankful, and we'll meet you again in the third workshop in memory of Joy Reidenberg.
Hello, everyone. Thank you all for staying back to listen to my presentation, and thank you to the the previous speakers and to Professor Ravid for organizing this event. Yeah, so I'll just get into it. So my paper that I wrote about was on facial recognition, particularly in the workplace. Just to give a brief overview of what my paper is about. It's a critique on the use of facial recognition in the workplace, and I chose to focus on the workplace because that is where, at least before COVID, people spent the majority of their time. While there is a general consensus among scholars and many regulators that facial recognition in most contexts should be banned or highly regulated, this paper takes what I would like to think to be a more practical approach and argues that it is possible to have facial recognition in the workplace so long as it is used responsibly and in the best interests of the end users, in this case would be the employees, in mind. So just to quickly go over, Professor Abril already, went over like the main four uses of facial recognition. I'm going to go over two main uses that are used in the workplace, and also a third one that's also gained, traction as well. So facial recognition is a biometric software application capable of identifying or verifying a person based on her facial contours. And there are two main uses that I discuss in my paper in terms of the workplace. So the first is identification, which is used to determine, for instance, who is entering a building. And the second is authorization, which goes a step further and essentially verifies that a person is who she says she is. It will grant a person access to, say, a particular area in a building if it determines that she has clearance to be there. And then the third use is one that I coined facial expression and personality assessment tool. If any of you are familiar with the video interviews, that's essentially what this speaks to, and I'll go a little bit more deeply into it and then in the coming slides. So now that we went over what facial recognition is typically used for, how does it work? Due to the limited time, I'm not going to go too deeply into it. I'll just highlight 5 main points of how facial recognition works. So the first is that, the software must be created. So that's step 1. Step 2, in order to perform its intended function, the software must be provided data, which is typically done using a neural network, which in this case is a means by which a computer learns what a face is and how to identify it. So, and then after that, there are people who present the images to the computer. These are typically called data providers, and they'll feed it millions of photos, and then they will task the computer to identify faces. The next step after that is to learn how to differentiate between the faces. To do this, they will have the software identify thousands of different mapping points on a face. It'll determine distance between, say, the eyes and the nose, or the nose and the mouth, whatever the case may be, in order to identify specific characteristics of an individual face. Again, they will feed the computer countless faces after they do this, where this time the program will take into account the mapping points programmed into the system. And for each distinct face the computer reads, it will associate it with a unique sequence of numbers that it will only use to identify that specific individual. So this slide speaks to the facial expression and personality assessment tool that I began to speak about earlier. To describe how it works, I used a hypothetical case study. So here there's Lawrence, a 27-year-old Black American with a BS in computer science from Boston University, who just interviewed with Goldman Sachs. However, he did not interview in the traditional way with a person at the other side of the table. Instead, it was conducted over a platform called HireVue, which is designed to do away with biases that human interviewers possess when evaluating the credentials of a job applicant. So HireVue uses a candidate's computer or cell phone to analyze their facial movements and word choice, speaking voice before ranking them against other applicants based on an automatically generated employability skill. And then this score is based off of the company's current top performing employees. So if you you know, the more that your tone of voice and your you know, even like the word choice that you use are similar to the top performing employees, the higher chance that you will score higher on this application. And here is just a quick clip. I don't want to go too much into it because I know that my time is limited. Just to, you know, give a brief overview of how HireVue works. I think I need to actually pause sharing for 1 second.
Take your time. Meanwhile, I would say, yeah, I'm not muted, that Catherine is the other representative of the Fordham IP Law Journal. She holds a high position in the journal, so she will be collecting feedback and to improve Yasmin's research. I would also like to say that Yasmin is part of our class that I teach at Fordham about the challenges of IP and advanced technology, AI, and blockchain. Yeah, you can move on.
Perfect.
Thank you.
Can you guys all see the video right now?
Yeah.
Okay.
Companies are using predictive algorithms and machine learning as tools to identify the best candidates. They're using AI to assess human qualities, analyzing everything from word choice to tone of voice to eye contact.
Now I just want to go a little bit towards the end of the video. This kind of goes into the pros and cons of using HireVue, which I thought was interesting.
When you have all the jobs on the internet, certainly employers have lots of choices, and so does job seekers, but those choices often can be overwhelming for both sides. What we find is the use of AI technology can enable a job seeker to find the best possible opportunities for them to apply for.
But body language expert Patty Wood sees some issues with these programs.
I don't want people to be excluded because they're not comfortable with this kind of interaction, who may be very good at human interaction.
On the flip side, Yale behavioral scientist Jason Dana says unstructured face-to-face interviews are overrated.
There's a lot of industrial psychology research showing that interviews aren't very good at predicting job outcomes. At least they're much less good than people think they are.
But even Dana sees some red flags.
You might have too much homogeneity in your organization and not enough healthy diversity of thought, right? You just keep hiring the same sort of person again and again. And that would be a danger.
For me, what I miss...
All right, I'll leave it there. And if you guys want, I could include the link in the chat later on. Go back to the presentation. All right, you guys all see the presentation again? Okay, perfect. All right, so now they're moving on to the debate over whether or not facial recognition should be banned in the workforce. So in my research, I have noticed that a lot of scholars have essentially come to the same consensus regarding facial recognition, and it's that it should be banned. Professor Woodrow Hartzog and Evan Salinger made the argument that though firms may justify the use of facial recognition technology by gaining the consent of the individual, this consent is illusory. There's no way for the individual to know what he is consenting to when he allows facial recognition technology to be used. And this is because the risks of the technology are still widely unknown and obscure. Furthermore, even if all the externalities surrounding the use of facial recognition were identified, consent would still be an issue because of the technology's ability to erode society's collective autonomy. Essentially, what they meant by this is that the right to the collective group or society should supersede those of the individual. Therefore, even if the individual agrees to have facial recognition software used on him specifically, if this impairs the way in which society operates, that consent, it should be deemed invalid. And then another scholar characterized, Luke Stark, he characterized facial recognition technology as the plutonium of artificial intelligence. He explains how the very nature of the way in which facial recognition technology works should alarm the public. The way that the software maps out and classifies human faces buttresses the discredited character classifications of gender and race, which will inevitably lead to social bias at a best case scenario. Essentially, in this statement, Stark is alluding to the ever-present issues surrounding facial recognition, which is biased, something that a lot of the previous scholars presenting today discussed. And as explained earlier, facial recognition has historically been statistically significantly less accurate on people of color, especially people with darker complexions and also women. So there have also been government responses to facial recognition. As Professor Abril mentioned in her presentation, Portland passed the toughest ban on facial recognition in the country in September of this year. It banned the use of facial recognition technology in both government and the private sector, which for the private sector, the ban will begin as of January 1st, I believe, 2021. And the ban would apply to all places of public accommodation, whether privately or publicly owned. However, companies would still be able to use facial recognition for purposes of verifying that a person logging onto a computer, a company-issued device, is the employee that he claims to be. And then there's also been federal legislation proposed this year. Also, Senators Bernie Sanders and Jeff Merkley co-sponsored the National Biometric Information Privacy Act of 2020. The bill would bar corporate firms from utilizing facial recognition technology on people without their consent. Further, the corporations would have to cite a valid business purpose for using the facial recognition, even if they did get the individual's consent. So then next I go into the uses of facial recognition technology in the workplace, and I identified 4 in my paper. The first is to replace the typical HR person-to-person interviews, which is like the higher view interview that I mentioned earlier in the slides. The second is used in place of or in addition to employee access cards to gain entry into a building or certain parts of a building. It also could be used to track when people, exactly when they enter the building for purposes of their hourly wages. It can also be used to track productivity. It knows how long you use the bathroom or knows when you're, chit-chatting. With your coworkers. There are some companies, especially in the financial sector, that will use facial recognition technology. They'll have you put a camera in front of your screen so that it knows exactly how long you're staying in front of your screen, and things like that. And also used to track an employee's mood so that a company can determine the atmosphere of the work environment. So some pros and cons to using facial recognition in the workplace. It allows companies to interview more applicants, which would, which it should lead to the company finding the best possible match for an open position. And in terms of the applicants, it also gives them a lot more flexibility in terms of when they can interview. A lot of, like, for HireVue, for instance, I've taken a few interviews over HireVue myself, and it usually will give me like a week time frame in order for me to be able to take the interview, so that, like, when I was in school, I wouldn't have to take time off from my classes and I could just take the interview at nighttime, which is, a big positive for a lot of people who can't afford to take time off either for childcare reasons or because, they have to work. Another advantage of using facial recognition is that is especially useful today in a post-COVID world where employees no longer have to clock in or come in contact with machines to gain access to a building. So it, from a public health and safety point of view, offers that advantage. And firms can use facial recognition software to gain insights into the atmosphere of the workplace. Some cons, however, is that it essentially replaces one bias for another. In terms of interviewing, while, the person-to-person interviews have their flaws, and surely anyone interviewing an applicant is going to have underlying biases when they interview. Facial recognition hasn't entirely done away with that bias. It just replaced it. depending on, the type of data that was fed to the algorithm, it could lead to different results for an individual applicant. Also, in terms of the video interview facial recognition technology, is that some candidates who could be a perfect fit for the job may just not be very comfortable interviewing in front of a camera and score poorly because of it. And, that's the only reason why they didn't get the job. So there's that to take into account as well. Also, people who know that facial recognition software is being used on them may feel like their personal privacy is being violated and feel like they're always being watched, and, give them a sense of paranoia while at work. Finally, when people know that facial recognition is being used on them, they may alter their behavior for fear of being scrutinized, which ties into the third point. And this could just stifle creativity and make people, not want to go against the status quo, because they know that they're going to be they know that they are being watched. So again, this is just another thing to consider when firms decide whether they want to use facial recognition. So I highlighted a few different legal privacy issues that come up as a result of using facial recognition in the workplace. I'll just pose a couple of them. Do people have a right to know when facial recognition technology is being used on them? Do they have a right to live anonymously in public without being subject to facial recognition? Do people have a right to know what becomes of their personal data after collected by facial recognition? And do people have a right of erasure if they decide they no longer want to subject themselves to the facial recognition? So I dove pretty deeply into three different theoretical justifications for privacy rights. The first one is offered by Professor Richard Posner. For him, there's no right to privacy, at least not in the sense that individuals have an unfettered right to conceal. Essentially, for Posner, privacy is not an issue. And he highlights three reasons why that's the case. The first is that privacy is not deeply ingrained. It's not a deeply ingrained right for people, which makes them more apt to give privacy rights up for small gains. He brings up the Amazon one-click function, and he says that people will willingly give up their credit card information, their home address, and other personal information in order to get a seemingly small convenience of being able to purchase whatever it is that they want with the click of a button off of Amazon. So that's number one. The second reason why he says that privacy is not that much of an issue is because of the use of technology nowadays. It's basically impossible to uphold privacy rights when people share a lot of their information with the internet. So he basically says that privacy, in the public at least, is now an illusion. And third, privacy also leads to inefficient transactions. This is the idea that when two parties want to enter into an agreement, they should both know all the relevant information that may pertain to the agreement. With privacy, however, people are allowed to withhold or conceal some parts of themselves, which prevent the parties from making the best informed decisions. So in my paper, I push back on Posner's no right to privacy argument. While it's true that people do tend to give up privacy rights for relatively small gains, they are aware of what it is that they're giving up. And essentially, they accept the terms and conditions. When it comes to facial recognition, consent is harder to achieve because people don't know exactly what it is they're giving up because the technology is still so new. And secondly, there are people who would rightly prefer to remain concealed. Minorities, for instance, who have been subject to police brutality would likely much rather prefer to live anonymously and have their images and footage of them, would rather not have images and footage of them out in the cloud and available for law enforcement to take when they want. And I know we're talking about facial recognition in the workplace. However, if it's available in the work, if their information is available in the workplace and stored in the cloud, there is a chance that the law enforcement would be able to, get access to that information. And a lot of people fear that from happening. The second theoretical justification, which is brought up by Professor Abril, is privacy as a property right. So essentially, and I hope I get this correct, individuals should be able to own all their data or the information about them as intellectual property. And people should be granted private rights so that they have temporary yet exclusive control over their privacy. In addition to private rights, a person may also elect to obtain private marks to protect his reputation and give him a right of recourse if anything or anyone misrepresents his character. This model offers much more benefits to the end user in terms of facial recognition. It would allow individuals to demand compensation when third parties profit off of their information. However, a downside that I posed could occur is that those in need of money might be more willing to subject themselves to facial recognition, which could potentially lead to abuse by those collecting their data. And then finally, there's privacy as a fiduciary right. This school of thought proposes that while people do not own their data, those who do use it do use an individual's personal information have a fiduciary duty over the data they collect. Fiduciaries have 3 duties. The first is confidentiality, and the second is a duty of care. These duties require fiduciaries to take the necessary steps to ensure that the end user's information is kept confidential and protected, meaning safe from being taken without consent. And then the third duty is a duty of loyalty, which is alluded to above. It's simply the duty of the fiduciary to put the interests of the end user over those of the fiduciary. So I would argue that this model might be ideal. It would likely work well in the context of facial recognition. For one, it would allow firms to use facial recognition technology in the workplace, but it would also require them to use it responsibly. If firms and facial recognition software companies themselves had fiduciary duties over the people who subject themselves to the technology, many of the privacy concerns surrounding facial recognition's use might be mitigated. People would no longer have to worry so much about how their faces are being stored or whether they are being sold to untrustworthy third parties, because those collecting the data would have a duty to put the end user's interests above their own. All right, and I want to quickly go through the last couple slides. As mentioned earlier, it's unclear whether the GDPR would work with facial recognition technology, especially in the workplace. However, it does propose some pretty useful solutions. The first is the right to disclosure or transparency, which would give individuals the right to know when facial recognition software is being used on them. Again, this is just one step, and we don't know how useful the right to disclosure is, and not just the right to disclosure, the consent rights. However, I think that it's still important to alert the public or employees specifically when facial recognition is being used on them. The second is the right to erasure, or the right to be forgotten. It's the right for individuals to have their personal data erased. In the context of the workplace, this could mean, if there's footage being collected on them, maybe every 6 months or whatever, all of that data is erased, for the duration of their time in the workplace. Finally, the right to object, which gives individuals the right to object to the processing of their personal data at any time. So these last 2 points that I want to make are more to do with bias than privacy, but I think that they were just important to highlight. So it appears to be that it's more obvious that facial recognition software used to interview or vet job candidates will often render skewed results based on race and gender. So to fix this, an easy solution would be to hire a diverse set of data feeders by the facial recognition technology companies themselves. And then another solution would be to require either the facial recognition developer companies or the companies that ultimately hire or use the facial recognition to devise a list of potential social consequences of using the AI software. While much of the software is relatively new and we do not know yet the full extent of its impact it will have on society, insisting that these companies take time to reflect on facial recognition software implications may actually have the effect of the software being used more responsibly and in a less intrusive way. And that is the end of my presentation. Thank you all for listening.
Thank you. You know that like there is a hesitation when you reveal a new topic to a lot of audience, but I think that's why we gave an option for people who are interested to stay and to give comments for the last, to give the opportunity to listen to you, because I think as I saw the presentation and I know from class that it was really deep and interesting and brought a lot of issues. So we'll give the floor to Catherine, who collected her own ideas and feedback and collected from the class, and just to improve, because it's, I mean, you've submitted the article obviously, but you still, if you want to get it published, so it's really interesting and important to get feedback. So whoever gets want to give some feedback, so you can write in the chat to Catherine, or the class can write in the email. Yeah.
Great. Well, thank you, Yasmin. That was a great presentation. I know it must be difficult presenting after the paper has been due. So good job with that and pulling all of that together. It seems like you have a really good understanding and grasp of all of the information. And you did a really good job researching. So thank you for getting that all done before. I do want to specifically say out front that your theoretical justifications, I think the way you handled that is great. Showing certain justifications, but then countering them is a great way in a paper to show that you really understand the material and show that these are real discussions that are going on. So I have lots of comments in different areas, so bear with me. And I'll try to go through quickly, and I can send you anything else that comes in after. So somebody said that maybe to include the idea that privacy is a fiduciary right, the theoretical justification, maybe in the beginning, just touch on that. Maybe focus on the negative effects a little bit more. I know that you mentioned them during the video as well, and you mentioned them at the end as well, and in your paper you probably did, but especially the biases against minorities and women, that's something that's very important today. It's a huge discussion going on across the world. So I think really focusing in on that can be very beneficial. Discussing the disparity between different countries and the way that they use facial recognition in the workplace. I know that you discussed GDPR, but maybe mentioning a few other ones. It might just be an interesting touch to add into your paper. Also discussing other IP theoretical justifications that we discussed in class, like the Lockean labor theory, personality theory. I think that's just something that can bolster your argument as well. Let's see. Maybe also discuss the ease of access of facial recognition, the actual data. And lots of AI is being used in open source. So maybe go into that a little bit more. Let's see, what else do I have? Yeah, I guess a lot of these echo the same things, focusing on really the downsides of what you've been discussing. And I can send you all of this in an email afterwards. Yeah, great job. It was really good.
Thank you. And thank you all for your comments. I had to condense it too. I know I went a little bit over the 10-minute time frame that I was given, but I definitely take your comments to heart and I appreciate them.
Good job.
Thank you.
No, so Catherine, there is something from Danny, so I'm sending it to you so you can raise it. I mean, Danny can also.
Great. So it says, do you think that employers make biased decisions and then blame the AI? They say, I'm going to be racist, but it's not me, it's the algorithm. So I think this is kind of getting at, using the AI to kind of cover those difficult decisions that they're making, or incorrect decisions.
Sorry, if there's more under the question, you can ask.
And then it just says, also, I want to be really careful. AI is not racist if it disqualifies people of color. It does not mean that it's more prone to be racist.
Yeah, so I would say, I would like to take more of a positive viewpoint of this and say that companies don't necessarily want to be biased and use AI, you know, for the reasons of like, you know, getting around hiring a less diverse workforce because, you know, it was the AI that chose this this applicant, and it wasn't us. Like, we had nothing to do with that. I think that generally speaking, companies have good intentions when they're using AI. It's just a matter of, in terms of, you know, when facial recognition technology is used, for instance, Amazon notoriously selected, when it used facial recognition technology, it notoriously selected a lot of male applicants for open job positions, because historically that's what Amazon, you know, hired in the past, and the AI, or the facial recognition technology's algorithm, was, you know, kind of set towards the male applicants and kind of overlooked all of the women. I don't think that Amazon had the intention of not wanting to hire women at that time. I think it was just a flaw in, you know, the algorithm itself, or providing the data to the algorithm, if that answers the question.
Yeah, okay. I just want to end up because we will have more time like to discuss it maybe more personally if you would like to pursue with the academic publication, but I would just want to mention two things, and then we'll really let the people abroad in Europe and Israel and other places to go to sleep, because it's really getting late. So what I would like to emphasize more is that what's so unique about employment, which is different from using AI facial recognition system in policing, or in, I don't know, commercial, in stores and other uses that we heard about, and we can, like airports and more, and medical and more. And I think there are two things, two sides of the coin. From on the one hand, we can say that it's more problematic, I would say, because of the overpower that employers have over their employees. So, I mean, if I'm getting to a place, like I'm working in university, and this university says, like, I mean, we use facial recognition, I wouldn't say no, because I want a job. I want to be employed by them. So that's on the one hand. So I don't think consent is really the issue here, and maybe we need more regulation. Maybe implicit consent, like the solution we heard from Europe, it's really interesting. On the other hand, I think it's less, I would say, dangerous or worrisome, because it's in the employment. So it's more like face matching for legitimate purpose, like did you enter the place, and it's more, it can be more controlled by the employers that keeps the data than in other places like police or governmental or commercial, some stores or Amazon or Facebook or Apple that collects my faces. So I think there are two sides of the coin, the two like perspective which are conflicting, and I think it's worth mentioning them. And I think that also the employers have a stronger fiduciary right over the employees than others, like Facebook. What's their fiduciary right over the users? So I think maybe it's even more toward being more legitimately used by explicit consent by employers. Although I can just say that in other countries, like in Israel, it was forbidden to use this kind of facial recognition in workplaces. But still, I think when you balance the pros and cons, it might be more for employers than by commercial entities. So yeah. And with that being said, I think it's an excellent project, and I think you really go deeper. And I'm thankful for Catherine to bring the positive aspect of the and to collect the feedback. And yeah, and with that, I know it was fascinating. I still getting like feedbacks from in the email and all over, like how wonderful and fascinating and important and cutting edge were the discussion. And I think, Yasmin, you brought, like you ended up this discussion for the open audience in a wonderful way, and I'm really thankful. So I would like to thank every one of you and to promote these discussions. And from this point, yeah, we said good night to everyone. And we just continue with the class themselves with 2 more presentations. We don't want to make other people tired. And if the articles will be published, so we'll expose them to the others or with the permission of the other researchers. But I think we have a great taste of what the challenges of facial recognitions are and what are the benefits. I think the industry point of view was amazingly interesting and to bring things from other perspectives. And perspectives, I think it's the key word over here. Okay, so thank you for everyone for joining and good night. And we just stay with the class. So yeah, I see a lot of my—
Thank you. Thank you. Goodbye.
Yeah, and Gidon and Aline and Majid. Yeah.
Thank you. Goodbye.
Yeah, it's great seeing you all.
Thank you very much, Shlomit.
Good night, Ziva. Thank you for a great question. Thank you, Judy. Yeah, and now we're just staying with the class. And the next one, I'm sorry, and I have to apologize to the class. It will take like hopefully only 30 more minutes. And we'll give the floor to Jessica, who is ready with the presentation, and then we'll end up with the last presentation of Ellison. And I want to say that they just wanted to present to the class, and I respected their decision. So it's just for us to give their feedback and to give them the floor. So Jessica, the floor is yours.
Thank you.
And apologizes for stretching the time a bit longer.
So my presentation is on the regulation for law enforcement use of facial recognition in the UK and the US. I became interested in this topic when I read the New York Times article on Clearview AI over the summer. Clearview AI is a facial recognition company that developed an app, and how it works is that you take a photo of a person, upload it, and you see the public photos of that person, along with the links to where those photos appeared. So the data set behind Clearview AI includes more than 3 billion images. And the most interesting thing is that it scrapes the entire internet for photos. In comparison, IBM last year received criticism for its database of nearly 1 million photos scraped from Flickr. And what's also interesting is that earlier this year, Amazon and Microsoft have announced that it would stop allowing law enforcement to use its facial recognition software. And IBM had announced that it would stop further research and development into facial recognition technology altogether, citing ethical concerns of the technology. However, this doesn't appear to be stopping law enforcement agencies from using facial recognition technology. Instead, they have now turned to smaller and more specialized companies. So more than 600 law enforcement agencies in the past year have started to use Clearview AI. And in the past summer, the US has had its first case of someone who was wrongfully arrested because of a flawed match from the facial recognition technology. So this occurred in Detroit, where a man was wrongfully arrested for theft based on a flawed match from the technology. The police department arrested him without asking for his alibi or what he was doing that day, and he was held for over 30 hours. And so current legislation does not really deal with law enforcement regulation in this, and it's mainly dealing with consumer protection of biometric information and biometric data. And what biometric information is, it's body measurements and calculations related to human characteristics. So for facial recognition, it's things such as the distance between your eyes and the distance between other features as well. So currently in the US, it's a lot of sectoral legislation that deals with certain uses of facial recognition in certain areas. So for example, HIPAA deals with the medical and health data. However, there are significant advantages to facial recognition, which is why so many agencies want to use this. It is efficient, it saves on human resources, it saves on transactional costs, and in areas such as retail, airports, and banks, it increases safety, prevents theft, prevents crime, prevents fraud. And law enforcement have used it to help find missing people, and it has also helped catch killers. Especially in COVID, facial recognition presents a significant advantage in that it decreases the need for direct human interaction compared to other security measures such as fingerprinting. And in banks, you can also use your face to make withdrawals. So there are concerns and legal questions regarding the use of facial recognition. There are privacy concerns, and there's a lot of issues with the data set. As mentioned before, it's a lot of concern about the accuracy of it. In laboratory settings, the accuracy rate is as high as 99.9%, but this does not translate into real life, because in laboratory conditions, you can have ideal lighting, you can see the subject straight on, you can see the subject's facial features clearly. However, in real life, especially now, people are wearing masks, and most likely people will be identified from angles. Additionally, in the UK, the civil liberties organization Big Brother Watch in 2018 and 2019 published their analysis on the police use of facial recognition technology. So what it showed was that South Wales police wrongly identified innocent people 91% of the time, and the Metropolitan Police had a false positive rate of 98% of the time. And out of the 104 times the facial recognition technology was used, it had only correctly identified 2 people, and one of them was put on a mental health related watch list, and the other was incorrectly put on a watch list. So as mentioned before, there are also racial and gender disparities in the data set. In 2011, a study found that the racial makeup of the development team affects the dataset and the accuracy of the algorithm. In 2018, a study done at MIT found that facial recognition tools incorrectly identify the gender of darker-skinned women as much as a third of the time in comparison to the 1% error for Caucasian males. And IBM's facial recognition tool was found to have misidentified gender up to 7% for lighter-skinned females, up to 12% for darker-skinned males, and up to 35% for darker-skinned females. And not only that, the fact that age, gender, and the fact that people's face changes also affects the accuracy of the data set. So currently, sorry, I'm going very fast. So currently, California, Illinois, Texas, and Washington, and New York have statutes directly governing biometric information privacy. For time's sake, I'll only briefly go over California and Illinois. So California's bill, the California Consumer Privacy Act, enhances privacy rights and consumer protection, and it's now presented as a potential model for a US data privacy law. So Illinois enacted the Biometric Information Privacy Act in 2018. It regulates private entities' collection, use, and storage of biometric information. It requires notice, and it requires informed consent, and it creates a cause of action for anyone who's been aggrieved by a violation of the law. So there are currently lawsuits against Clearview AI, and they have been filed under the Illinois Biometric Information Privacy Act. And similarly, the Illinois Act also enabled a class action suit against Facebook for $550 million for its allegedly illegally obtaining biometric data through a photo tagging tool. So on the federal level, there are 2 statutes that the FBI uses to govern its use of facial recognition technology, mainly that it requires them to do an impact assessment and to follow the fair information practices and principles when it uses facial recognition technology. So in the UK, we have the GDPR, and in the EU, we have the GDPR, and in the UK, we have the Data Protection Act, the DPA. The DPA protects similar things. However, there are differences between the GDPR and the Data Protection Act. And in Europe, we also have a right to privacy in the European Convention on Human Rights Article. Article 8 is the right to privacy. And mainly what it says is that you have a right to privacy without interference by a public authority, except such as in accordance with the law and is necessary in the interest of public safety. So here is an image of the status of facial recognition in Europe. This is as current as of July 11, 2020. It's interesting to note that only Belgium has banned it, but it is not banned by law. The Luxembourg Prime Minister spoke up against the use of it, and it has been found to be in breach of law, but not officially banned. So I chose UK because there was a recent landmark case that ruled law enforcement use of facial recognition technology was unlawful. So what happened was South Wales police used real-time facial recognition technology in a public place to find suspicious people on their watch list. And a citizen, Ed Bridges, who was not on that watch list, was tagged and identified 2 times, and he filed a suit claiming, among other things, that the use of facial recognition interfered with his right to privacy, and that the police violated the public sector equality duty of the Equality Act of 2010. So the High Court initially ruled that the use was lawful. However, however, recently, the Court of Appeals has overturned it and said that the use was unlawful. So the court said that it did violate his right of privacy because it was not in accordance with the law. So usually if it's in accordance with the law, it's for a stated purpose and it is necessary. So the court found that it was for a stated purpose, which is to prevent crime and for public safety. However, that the measures that the police used were not necessary. And they found that it wasn't necessary because the use of it gave the police an impermissibly wide amount of discretion in determining who to place on the watch list and where to deploy it, which is why the use was not necessary and therefore the use of it was unlawful. For the Equality Act claim, the statute states that a public authority must, in exercise of its function, have due regard to the need to eliminate discrimination. So here the court held that the police did not take reasonable steps to make sure that there was no bias in the data set. They did not do an independent verification after they received facial recognition software. And this is why that it violated the Equality Act. So this case, in my opinion, is a glimpse into the future for the US. As the US currently has not used real-time facial recognition, I feel that it's only inevitable before we do start to use it. And so this case shows how a court can go about analyzing such a use. The impact of this case is that it has no precedential effect in the UK, mainly because the commissioner has stated that this only applies to the specific set of facts. So in the US, I won't read through all of these case law, but in the US, most likely the Fourth Amendment will not apply to facial recognition when it's used in surveillance of activities that occur in the public. So my solution, my proposal is by looking at what happened in Bridges and to implement law enforcement agencies to do independent research before they use facial recognition technology to see if there's biases and to see if there's a way to combat that. And after they do that investigation, have a transparency requirement that requires them to public the results of their research, and that way that the citizens and civil liberties advocates can hold them accountable. The drawbacks is, as mentioned before, the case law is not very much on the side of having such requirements, and also there's a legitimate interest to maintain public order. So the conclusion is that there's significant advantages to using facial recognition technology. The use of it is inevitable, even though major facial recognition softwares have a moratorium. Law enforcement agencies can turn to smaller and specialized companies for the use. Legislation most likely it currently has some legislation pending. However, most likely it will be up to the states or the cities. And some cities have already passed ordinances that forbid the use of facial recognition, such as San Francisco and Seattle. There's also a lack of transparency in law enforcement use of facial recognition technology. And I feel that having such a transparency requirement would help regulate facial recognition use.
So wonderful, and also I appreciate that you kept the time frame so wonderfully, and really, really enjoyed with a specific focus. It means that many people can write about the same topic, but with each one with a specific area that is more interested in. Okay, so Ziva will give the feedback on behalf of the class, unless someone wants to unmute, but yeah, Ziva.
Hi, Jessica, great job. So I liked your whole presentation, but I really liked that you opened up with the pros and cons and examples and used really attention-grabbing material, such as the wrongful arrest. And I know that we mentioned this already, that there's bias to believe the technology, but I think that could be really stressed in that point. For the advantages, I like that you used a COVID example and less human contact, because I think it's really relevant to what's going on currently. And I thought that it was a very thoughtful example. And then overall, I understand where you're going with your solution, the independent research into the data sets, but I think that you could expand a little bit about how that would actually be done. Because it seems like for such big scales of data, like you would need artificial intelligence to sort through that to maybe find the bias itself, and there could be bias in that. So I think just to give the reader a better understanding of how your solution will be implemented will make your argument much stronger. And then from the class, I will send comments as they come in. I currently only have one comment, which is that they really did like the differences in the accuracy between the different races of your stats. That was a very striking example, and it added to the statistic. And then that it could be helpful to go into a little more detail on the current use of facial recognitions by the police departments and just expand on that. But overall, excellent job, and I will send you more feedback as it comes to me.
Okay, so thank you, Jessica, and thank you, Ziva, and thank you, also Catherine and Stephen for helping. I just want to say, of course, you submitted the article, and yeah, I'll consider when I read the paper, the final paper that you didn't present in class to get an A. But I would say that the same thing I said about employment, like you have to bring the uniqueness if you want to further develop the article, the uniqueness of policing versus other users. And I think also the fact that it's police, maybe it's more regulated, but than other entities, like more commercial ones. But on the other hand, you have to bring the risks of having the police more, to empower the police with facial recognition, which can be wrong due at the end of the day. And what can the citizen do against the police, where the gap in power is even much larger, much bigger than with employment. So I think you have to, and maybe to bring some more examples from the Black Lives Matter riots recently, misuse of facial recognition by the police. That's one thing. The other thing is that I wonder about the model. And I said, if you want to further develop the article, so the model, and I agree with Ziva and with other students from the class, that it should be more developed. Like, how would you are going to implement that? How can we enforce anything on police, on other enforcement entities? So I think there is more to do here to explain what are we going to do with it and how it can be implemented. But other than that, as I said, I think it's a very interesting topic and very challenging. And I think you addressed it very, very nicely and very deeply, and bring a different perspective on that. And I really appreciate that. So thank you, Jessica. Thank you, Ziva. Jessica, do you want to answer like any of them? Jessica, you are on mute, but would you like to answer any of the comments or the feedback?
So for the model, I was thinking mainly about having them to do an independent verification. I think the only thing that I thought was doing independent verification, similar, I guess, to how similar to how like liability insurance would work for police, having something like that in place, similar for transparency and for the use of facial recognition when they use it.
Okay, great. So last but not least, in our course, I really enjoyed everything, and all the presentation was so great. And so we have Ellison.
I will try to go as fast as Jessica, but I do not know if I can go that quickly.
Yeah, but I think the fake, who you said, fake identity, fake images is really interesting, and it's a wonderful, wonderful topic to end up the wonderful, amazing, fantastic course that we had.
I'm trying to share my screen. It's saying that
you are. You should.
Can you see it?
Yeah. Wow.
Oh, great.
I'm gonna be there.
Okay, so the topic that I'm looking at is deepfake identity appropriation, and I'm trying to figure out a way to solve this very complex problem with the right of publicity.
Yeah, because I think it's too long of a record. So I'll cut the record and start again.